deceased adults?
They do.
And were your duties the same on August 27th of 2021?
They were.
And what's your educational background?
I have a bachelor's degree from the University of North Carolina at Chapel Hill and a master's degree from the University of Georgia. And after getting my master's degree, I was a high school teacher here in Fulton County for about 5.5 years before going to medical school at Morehouse School of Medicine here in Atlanta. And then after graduating from medical school, I did a residency in anatomic and clinical pathology at Emory, and then an additional year of forensic pathology fellowship training at the Fulton County Medical Examiner's Office in conjunction with Emory.
And do you have a specialty?
I do.
And what's that?
Forensic pathology.
And can you tell us what pathology is?
Well, pathology in general is the study of disease and trauma on a person's body.
Okay, and how does the forensic part play into that?
Forensic pathology is a subset of pathology, specifically trying to determine the cause and manner of death of people who die sudden, unexpected, or unexplained causes and as a result of trauma.
And are you board certified?
I am.
Can you tell us what board certification means?
It means that you've completed either a residency and/or fellowship and then passed a qualifying exam.
And are you a member of any professional societies?
Yes, I am.
And what societies are those?
The National Association of Medical Examiners.
Okay, and have you ever testified in court before?
I have.
You know about how many times?
Probably over 100.
Okay, and during the course of your career, can you give us an estimate of about how many autopsies you've performed?
I've either performed myself or supervised pathology residents and fellows approximately 4,000 autopsies.
And have you been qualified as an expert before?
I have.
And have you ever been denied an expert?
I have not.
And when you were qualified as an expert, was that in forensic pathology?
It was.
Okay. At this time, I would like to qualify Dr. Karen Sullivan as an expert in forensic pathology.
No objection.
You may proceed, Ms. Willingham.
Dr. Sullivan, can you tell us what an autopsy is?
Well, an autopsy is both an external and an internal examination of a person's body to determine their cause of death. And the external examination is much like you would get when you go to the doctor or you take your child to a pediatrician, looking for any external evidence of trauma or natural disease, looking at a person's height and weight, and any external evidence of trauma and natural disease. And then the internal examination involves examining the person's internal organs, again, looking for natural disease processes and injuries.
And on August 27th of 2021, did you perform an autopsy on an individual by the name of Shamir Poole?
I did.
And can you tell the jury how the body presented? Well, would it help you first? Let's start here. Dr. Sullivan, I am showing you what has been previously marked as State's Exhibit 77. And do you recognize that?
I do.
And how do you recognize it?
It's a copy of Ms. Poole's autopsy report.
And is it a fair and accurate representation of the autopsy report for this case?
It is.
Okay, and at this time, the state would tender State's Exhibit 77 into evidence?
Say it real quick, please.
Judge, my client's telling me the screen is not on in front of her. Can that screen be turned on? Huh? Okay.
No objections.
Are they turning it on?
All right, and for the record, it looks like we
Huh?
do have the screen reactivated.
The state would.
Oh, there's no objection. State 77 is admitted without objection.
And Dr. Sullivan, can you tell us what the seal, can you tell us whether the body presented sealed or unsealed?
It was sealed.
Okay, and can you tell us what the seal number was?
The seal number was 2196349.
And what is the purpose of the seal?
To make sure that once the decedent is secured in the disaster bag, that no material enters or exits the bag until the decedent's ready for examination.
And did you document the findings of the autopsy?
I'm sorry, of which part of the autopsy?
Did you document the findings of the autopsy?
Oh, yes, I'm sorry, yes.
And how was that done?
There's a summary of findings on the first full page of the autopsy report.
Your Honor, permission to publish State's Exhibit 77.
Granted.
No objection.
Okay, and Dr. Sullivan, and I think you may have gone over this already. What is the purpose of assigning a case number?
Well, each person whose death is reported to our office gets signed a unique case number in sequential order as deaths are reported. And every piece of evidence that we have, for example, blood samples or urine samples, the autopsy report, all are associated with that case number and therefore that particular decedent.
And let's go to page 2 of your report. Dr. Sullivan, can you tell us what the reason you identified for performing this examination was?
We had received information from the investigating agency that Ms. Poole, who was 33 years old, was shot by another individual and was pronounced dead at the scene.
And is that a common reason to perform an autopsy?
Yes,
And why?
because everyone who is thought to have been injured by someone else and died, then we investigate their death and do an autopsy because of the involvement of the other person.
And who requested you all do that autopsy?
Well, it's part of the state statute as our responsibility as the medical examiner.
And now, looking at your report, can you kind of walk us through the summary of findings?
So in the summary of findings, I put pertinent positive and negative findings. And under Roman numeral 1, I document that Ms. Poole was shot in the head, that it entered the right side of the parietal scalp, which is the right side of the head. There was neither soot nor stippling or gunpowder residue that I saw on her skin, that the projectile passed through her right parietal scalp, her skull, her brain, her skull again, and then the left side of the occipital scalp, which was the back left side of her head. There was the exit wound there on the left side of the occipital scalp, and no projectile fragments were recovered. And the direction of the projectile was front to back, right to left, and downward. Ms. Poole also had a superficial abrasion or scrape on her left elbow, and she had no active natural disease processes that I identified during the autopsy.
And
What, right?
And Dr. Sullivan, I am going to show you what has been previously marked as State's Exhibits 78 through 95. Do you recognize those? I'm sorry, as you look through those, were there photos taken during the autopsy?
Yes, there were.
Okay, and I've given you State's Exhibits 78 through 95. Do you recognize them?
I do.
And how do you recognize them?
They're copies of photographs of Miss Poole taken during the course of her autopsy.
And are they a fair and accurate representation of how the body looked when the autopsy was performed?
Yes.
The state would tender states exhibits 78 through 95.
No objection.
Admitted without objection.
And Dr. Sullivan, we're gonna walk through those photos and I'm gonna have you kind of explain your summary of findings again so you can kind of explain to us what that path looks like, okay?
Okay.
Permission to publish?
You may.
All right, Dr. Sullivan, can you tell us what we're looking at here?
This is a photograph of Miss Poole's identification tag that was secured with the red plastic seal that was numbered 2196349 before the seal is broken and the disaster bag was open.
And moving to State's Exhibit 79.
This is a facial identification photograph taken of Miss Poole, and I believe on her chest is a placard that contains her case number.
And is it common for you all to take that photo?
It is. That's one of the standard in the series of photos that we take.
And moving on, can you tell us what we're looking at here?
Here, Ms. Poole is laying face down on the examination table. Getting a full back picture of an individual is also one of the series of photographs. On the left side of the back of her head is the exit of the gunshot wound.
Can you, the screen up behind you, can you just go point to where you just referred to, please?
This is the exit wound.
Thank you. Okay, and what are we looking at here?
This is a closer view of the exit wound on the back side of the occipital scalp or the back of the head.
And what about here?
This is a photograph of the entrance wound of Miss Poole here, where her hair has been shaved so that the entrance wound can be visualized.
And how are you able to determine the difference between the entrance and the exit wound?
Well, the entrance wound, since the bullet is piercing the skin from the outside, scrapes the skin and produces an abrasion around the defect. So the pink area of tissue is the abrasion. The smaller, darker center is the actual entrance wound. Exit wounds, in most cases, do not have an abrasion ring because the bullet is piercing the skin from the inside out. So there's not going to be an abrasion ring on the external surface of the body.
Is this that same wound you were just showing us?
It is. This is another view of the entrance wound.
And here?
This is a closer view of the exit wound, and you see there is no abrasion on the outside of the skin. You're just looking at the tissue within the depths of the exit wound.
And is this just a closer photo?
This is a closer photo of the entrance wound.
Okay. Okay, Dr. Sullivan, what are we looking at here?
So here, this is Ms. Poole's skull, as though you're standing behind her at the top of her head. The scalp has been incised and reflected forward and downward in order to expose the skull. And here on the right side of the skull is the defect in the skull that corresponds to the entrance wound that was on the right parietal scalp.
And it looks like there's some cracking there. Can you explain that?
Yes, those are skull fractures that are extending from the entrance wound onto the rest of the skull.
And is that common with an injury such as this one?
It is.
In which, it looks like we might be looking at a wound here. Can you explain that?
Yes, it looks like this might be part of the exit wound, but it's hard to see given that some of this tissue has not been removed yet.
Okay.
This is the entrance wound defect that's under the entrance wound on the right side of the parietal scalp.
And what's that dark spot over there that we're looking at?
So there's areas of hemorrhage in the soft tissue that attaches the scalp to the skull,
And what is that hemorrhaging caused by?
caused by the gunshot wound.
And what's this?
This is another view of the entrance wound defect and hemorrhage in the scalp.
And what is this?
So here, the temporalis muscle, the muscle that you can feel when you clench your jaw, has been reflected away from the skull, and there's hemorrhage within that muscle.
And what are we looking at here?
This is a closer view of the entrance wound defect.
And what are we looking at here, Dr. Sullivan?
So this is Ms. Poole's brain, and the calvarium, or the top of the skull, has now been removed. And there's hemorrhage, that's the darker areas that's associated with her brain, and that's due to the gunshot wound.
And what about this one?
This is just another view of the entrance wound defect taken from the inside of the skull.
And I believe this is the last one.
So here, this is the base of Ms. Poole's skull. The brain has been taken out. You're standing at the top of her head, and there are multiple skull fractures. This is towards the back of the head and across the middle cranial fossa, which is this area. There's a fracture.
And I'm gonna move back to State's Exhibit 77, which is gonna be the report. And you mentioned soot and stippling. Can you explain that for us? When would soot or stippling be present?
When a handgun is fired, the burning of the gunpowder is what propels the bullet down the chamber and out of the muzzle of the gun. When the gunpowder is fully burned, it produces soot, sort of like a log burning in your fireplace produces ash. That soot doesn't have a lot of mass, so after a distance of about 12 inches from the muzzle of the gun to the person being shot, after about 12 inches, soot falls away and you won't see it on a person's body. Also exiting the muzzle of the weapon with the soot and the bullet are burning and unburnt gunpowder particles that can strike the skin and make little scrapes in the skin, abrasions, and those abrasions are called stippling. For most handguns, after a distance of about 3 feet, then those burning and unburnt gunpowder particles don't have enough energy to reach the person's body. And so you won't see either soot or stippling on a person's body. Each of those, the appearance of soot and stippling is also dependent on any clothing that the person might have on that's being shot, or any intervening object between the muzzle of the gun and the person who is shot.
And Dr. Sullivan, looking back at your report, what does cause of death mean?
Cause of death means what happened to the person that caused them to die.
And what about manner of death?
Manner of death means how did the cause of death come about?
And can you explain to us how you distinguish between the two?
Well, cause of death means what happened to the person. So in Ms. Poole's case, she was shot in the head. She had a gunshot wound of the head. There may be someone who has a heart attack, and so their cause of death would be the heart attack, or someone who has a drug overdose, and the cause of death would be the fentanyl or whatever drug that they used. The manner of death means how did the cause of death come about? So if someone is shot by another person and dies, then the manner of death is a homicide. If a person shoots themselves and dies, then the manner of death is a suicide.
And what was the manner of death in this case?
Homicide.
And what was your overall opinion in this case?
That Ms. Poole died as a result of injuries that were incurred when she was shot by another individual. And those injuries were to her skull and brain.
And just for clarification, how many gunshot wounds did you find?
One.
Thank you.
Any cross-examination?
Yes, briefly, Judge.
Good morning, Dr. Sullivan.
Good morning.
I appreciate your service. 4,000 autopsies, that's quite impressive. From your findings, you can't tell, obviously, who shot Miss Poole, can you?
I cannot.
You can't even tell us what caliber weapon was used, can you?
I cannot.
No further questions.
Any redirect on those points, Ms. Willingham?
Nothing from the state.
Can Dr. Sullivan be excused?
Yes, Your Honor.
Thank you, Dr. Sullivan.
Thank you.
Take care. State may call its next witness.
State would rest.
All right, Mr. Strozier, is there anything we need to take up? All right.
Outside the presence of the jury.
All right, members of the jury, we need to take something up. Should last about 10 to 15 minutes, and we'll have you back here in a moment. Thank you so much.
That's for the jury.
Thank you, Deputy Scott. Mr. Strozier, floor is yours.
Your Honor, I would move for a directed verdict. It's the defense's position that the state hasn't put forth prima facie case to allow it to go to the jury for deliberation.
Any argument you want to present to flush that out?
No, Judge, they just haven't provided sufficient evidence that inculpates my client, that points to my client. Frankly, the most of the evidence they produce points to Morris Reed. That's why I'd move for a directed verdict.
All right, Ms. Willingham.
Your Honor, Morris Reed testified that he saw the defendant shoot the gun. There was testimony from Ms. Jordan, there was testimony from Mr. Waters, and there was testimony from Ms. Demetria Poole, who all testified that they were inside the home at the time the shots were fired. Mr. Morris also testified himself that those people were inside the home at the time the shots were fired. The state re-indicted this case to be a felony murder, and the basis of that is an aggravated assault, and it's based on shooting at, toward, or in the direction of. Mr. Morris has stated that the defendant was shooting towards the home in which the victims were in. So based on that, we do believe that we've met our burden.
All right, but among these witnesses, though, it would be solely Mr. Reed who is the only one who said to actually have seen the shooting, right?
Yes, Judge.
Okay. And I know we had ID established several times. Who'd we establish venue through?
Through quite a few of the witnesses, Judge. I know that Ms. Jordan acknowledged the location of the home and that it was in Fulton County. I know that Johnson also talked about Crime Scene Tech Johnson talked about the location of the home he responded to and the county. Michael also testified as to the location of the home and the county. Demetria Poole also testified as to the location that she responded to and the county.
All right, thank you, Ms. Willingham. All right, so as to the motion for a directed verdict, it's my understanding that the standard is to resolve or to look at that evidence in the light most favorable to the state, giving them the benefit of all the inferences. This may be a single witness case with Mr. Reed. Is the jury going to believe Mr. Reed? Are they going to believe Mr. Reed was involved in some way? I think that's something for a question of fact for the jury and for counsel to attempt to persuade them during argument. As I anticipate, there'll be the jury instruction, a single witness, if believed, can establish that fact. So based on the testimony of Mr. Reed, I believe that the case is sufficient to make it through a directed verdict. So I'll deny the motion there. Anything else, Mr. Strozier?
I'd like to take about a 2-minute bathroom break before my client testifies.
Okay, that's perfectly fine. Whenever you make it back, we'll go ahead and just go and bring in the jury, Deputy Scott. We'll be in recess.
Thank you. Oh.
Officer, are you here for this case or are you here for something else today?
For this case, I was told I may need to,
Okay, all right, that's fine. I just want to make sure you weren't for one of the other motions hearings I got. Reschedule?
So sure.
What's that? No, Boyd's messing with it. Yeah.
Where does it 911 call? Let's play it quick. You got it on the phone? Play it. Is Miss Willingham in here?
I am.
She has this 911 call that she got from a Freedom of Information request. Can you come over here and listen to it? Make sure, see if you have an issue with it.
How do I know how she got it?
The open records request.
What was that?
I have a CAD report as well that was emailed to me.
Get authenticated.
It's in the CAD report. I have it. I have a
They would
copy.
have.
We have to, we have to have that live person here. Have to know who that person is and have them in here to authenticate it. We'll let you talk about it. So you're going to object to the introduction? Okay.
All right, we ready to go back on the record?
We are.
All right, let's go back on the record. Mr. Strozier, anything we need to take up before we bring back in the jury?
No, Judge. My client, wishes to testify. Huh?
It was a video that I wanted to show.
We're doing the still picture of the shot up car.
What about the 911 audio recording?
Well, it's not going to be introduced because we can't, because we don't have the person. It's dead. Leave it alone.
All right, not hearing anything. Ms. Willingham, anything we need to take up before we bring the jury back?
Nothing from the state.
All right, then Deputy Scott.
How many can you say, you called 911 to that day too, didn't you? Yes.
Yes.
You were screaming. Yes. What were you screaming? Got it?
Yes.
Rise for the jury. Here's the president.
Thank you, Deputy Scott. Members of the jury, the state has rested their case in chief. And we would now turn to the defense. I just want you to keep in mind, there's no burden of proof upon the defendant whatsoever. And the burden never shifts to the defendant to introduce evidence to prove his or her innocence. That being said, the defense can present evidence if they would like to. Mr. Strozier, does the defense have any evidence to present?
Yes, Judge. Defense called Andrea Rivers.
All right, Ms. Rivers, if you could make your way up.
Raise your right hand. Do you swear or affirm that the testimony should be in the court is the truth and nothing but the truth so help you?
Yes.
May be seated. Please state and spell your first and last name for the record.
My name is Andrea Rivers, Andrea Rivers.
Judge, may I remain seated for my convenience, please?
You may, sir.
Ms. Rivers,
Yes.
I'm going to ask a couple of just brief questions that so the jury can get to know you a little bit. How old are you?
46.
Have you ever been in any trouble in your life?
No.
You have a license to carry a concealed weapon, don't you?
Yes.
How long have you had that?
Since 2005.
And have you ever been accused of misusing the privilege to carry a gun in public?
No.
Have you ever had an altercation before, where you had to consider drawing your firearm?
No.
I want to direct your attention to the events of August the 24th. Why did you go to Thomasville, that neighborhood that day?
My daughter called me. I went to go pick up my daughter, my grandbaby, and her belongings. She had got into an altercation with her baby dad, Michael Waters, and I was just going there to pick my daughter up, and that was it.
And you were a little bit reluctant to go, weren't you?
Yes, I was.
Would that be because your daughter had a history of fights with Mr. Waters where they turned around and reconciled?
Yes.
And so you were reluctant to go get involved to begin with, weren't you?
Yes, I was.
When you went there, you didn't even pull into the
Leading.
apartment.
I'm sorry,
complex,
objection
did you?
leading.
All right, there's an objection to leading. So, Mr. Strozier.
Tell us where you parked when you arrived, Ms. Rivers.
When I arrived, I parked outside the apartment complex along the curve
Why was that?
because that was a dangerous area and I didn't like going over there. Too much stuff happened.
All right, and did you give your daughter any specific instructions about?
Objection leading.
I think we need to hear the full question first before I can rule on that. Mr. Strozier?
Tell us any instructions you gave your daughter about being ready to be picked up.
I asked my daughter, did she call the police? And she told me she did. I told her to have her belongings ready. I was coming and I was picking her up and she said, okay.
When she called you, did she call you from her telephone?
No, she called me from Mr. Morris' Reed phone. Mr. Michael Waters had broke my daughter's phone during the altercation.
Okay. All righty, so, I want you to walk us through the sequence of events that led up to this that led up to this gunfight. All right? What did you do when you arrived?
When I arrived, I observed the scene. It was a crowd of people, at least about 30 people outside. When I seen Mr. Lamar, he was waving me down because I called him to see where they was located because I didn't know. That's when I parked on the side. I got out my vehicle, my daughter and Mr. Lamar. They was both out on the sidewalk. They started.
Lamar, do you mean Morris Reed?
Yes, Mr. Morris Lamar Reed.
Okay.
They was on the sidewalk. My daughter told me what happened, and she said she was missing her ID and her bank card. So Mr. Morris and my daughter, they proceeded to walk down the sidewalk. I was coming behind. As I was walking down the sidewalk, I saw Miss Demetria Poole. She was sitting on the air conditioner unit. And when I looked at her, I said, y'all was wrong for throwing my daughter out. She been staying here for over a year. That's wrong for eviction. Miss Demetria Poole looked at me and told me, bitch, she finna go today. So I looked back at her and I told her, bitch, this the gutter. She said, your daughter is out here. I said, she's out here with her baby dad and her child. They have a family here. Demetria got up. She walked inside of the house. Her mom and everybody else was in the house. Mr. Water was also in the house. Mr. Lamar, he walked in and I walked in behind Mr. Lamar. My daughter was also inside of the apartment. She was sitting at the edge of the sofa on the arm. So my daughter asked Shamir to get her ID. As she sat on the sofa, Shamir said, okay. She proceeded to go upstairs to get my daughter ID. And my daughter ID, the one she brought, was expired. My daughter said, that's not the right one. Shamir said, okay, I'll go back up there. And at this time, when Miss Shamir was upstairs, Morris, he decided to grab my daughter. He grabbed her by her arm, and she was telling him, let me go, get your hands off of me, you hurting me. And he let her go and look and grab me. And I told him, get your hands off of me. I don't know you. I was standing in the doorway. I stepped back. Mr. Lamar, he was standing right there. My daughter was still sitting on the arm of the chair. So when Shamir came back down the step, she gave my daughter her ID. I looked at Miss Shamir and I said, thank you. We finna go. Nothing was going on. Nobody was arguing or anything. Everything was fine.
Did anybody, other than you realize that you had a weapon at the time? Your weapon wasn't exposed, was it?
No, I never brandish my gun. I keep my weapon under my shirt. I use an inside holster. So when I put my gun in my holster, it's inside my clothes.
And it was a small compact pistol designed to be concealed, correct?
Yes.
All right, all right. So, all right, so you can pick back up now. So nobody at that point, other than possibly your daughter, knew that you had a weapon.
Yes.
Okay, keep on.
So as I turned around to proceed to go down the steps, Mr. Morris Reed was behind me. My daughter, she was still in the apartment. She was supposed to be coming behind Mr. Reed. Once I got to the first step, Mr. Reed heard the door close. My daughter got locked in. He grabbed me around my neck. When he grabbed me, I went back he seen my weapon. Mr. Lamar grabbed my weapon from my holster. It was a struggle. I grabbed his arm, trying to prevent him from killing me with my own weapon. We fell. We was on the ground, tussling. Mr. Lamar had control of the gun. The gun went off about 2 times while we was on the ground. As I was on the ground, I heard gunshots, rapid gunfire coming out the door. My daughter was like, "Mama, run." I got up and I'm running. I'm running toward my car. We're being shot at by multiple people, the neighbors and stuff. Mr. Waters had told the neighbors to go get the stick. They joined in. They was fighting, running behind us, shooting at us. I almost made it to my car, me and my daughter. Mr. Lamar tackled me and my daughter from behind. As he tackled me, I'm on the ground. My daughter gets up first. When he tackled me, the gun was on the ground. I'm trying to proceed to get in my car. Gunfire is steady coming. My car is being shot up from all directions. I was able to get in my car. I crumped my car. I put my head down and I just mashed the gas. And I called 911.
Let me stop you for a second. I want to show you a picture. Give me that picture. Just get one of you. All right, I'm gonna have Mr. Sheldon approach you and show you what I'm gonna mark as defense exhibit number 1. And I want you to tell me if it's a true and accurate depiction of the condition of your car
Okay.
after it had been Swiss cheese with bullets. Hold on.
Yes, that's an accurate picture.
Stacy,
Yes, Your Honor.
I would move to admit that as defense exhibit number 1, Judge.
Any objection?
Your Honor, there's no foundation been laid yet.
Have you laid a foundation?
Witness testified that it was fair and accurate. Why don't you, Mr. Strozier, why don't you ask to see if, I think
That's
there's,
what I would say, Judge.
I think you had her confirm whether it was fair and accurate depiction of her car.
Is that a fair and accurate depiction of your car, Ms. Rivers?
Yes,
And if you could just lay the time frame.
And is that a fair and accurate description of your car on August the 24th?
yes,
All right, an objection from the state?
Nothing, Your Honor.
All right, defense exhibit 1 is
All
admitted.
right, Ms. Rivers,
yes,
so did I hear you say all right, so you're telling us that Mr. Reed tackled you. Did he tackle anybody else at the same time?
my daughter.
You have any idea why he would do something like that?
He was
Objection,
high.
speculation.
You need to,
Did he say anything that gave you an indication why he tackled you?
No, I didn't even know he was running behind me.
Did he holler for people that say, hey, she's over here?
Yes, he was holding me. He was trying to get them to come. They was shooting, and he was trying to get them to come over there and shoot me and my daughter.
So it sounds like a very chaotic situation, correct?
Yes,
But you were literally running for your life, right?
yes, I was.
You in fear for your life?
Yes, I was in fear for my life, my daughter's life, my grandson's life.
All righty, and did you at any time fire into the house or towards the house?
No, I did not.
in fact, that we've heard testimony that indicates that your daughter could have still been in the house.
Yes,
And so it would seem implausible that you would shoot into a house where your daughter is. So I want to be real clear. But the pistol came out because Mr. Reed grabbed it, right?
yes, Mr. Reed grabbed my gun out my holster. He had control of my gun.
And that's when the gun went off.
Yes,
Did you ever squeeze off any shots into or towards the house?
no, I did not.
Did you did you go to Thomasville it was morning time, correct?
Yes,
Did you go there looking for any trouble at all?
no, I did not. I went to go get my daughter and grandson. That was it. I had no intentions of doing anything but to pick up my daughter, my grandson, and get her belongings and leave to take my daughter and my grandson to safety.
And you carry a firearm in normal course of business just for your protection, correct?
Yes, I do.
Sometimes Atlanta isn't the safest place in the world.
No, it isn't.
And I think you and I can both agree that it was a terrible, what happened.
Objection,
on the
leading.
24th was a terrible tragedy.
Let's say, Mr. Strozer, the state has objected to leading. I think you need to rephrase.
I'll pass the witness.
All right, Ms. Willingham, any cross-examination?
Good morning, Ms. Rivers.
Good morning.
Ms. Rivers, you were asked about whether or not there's ever been another incident of you using your firearm inappropriately, correct?
Yes,
Is there an incident where Michael Waters was present in December, the year right before this incident happened?
I didn't understand what you
This
said.
incident happened in August, in that December before, so that would have been December of 2020. Was there an incident where your firearm was pulled out and Michael Waters, Nene, and your grandson were present?
No,
And you stated that Dee Dee was inside the home. Miss Jordan, Michael's mom, was inside the home. Nene was inside the home, and Shamir was inside, correct?
and Michael Waters was
Michael-
inside the home as well.
Okay, and what was Nene doing when you left out of the home?
She was sitting on the edge of the sofa. She was waiting on Mr. Lamar to come out. Then she was getting out. It was a small space.
So she was waiting on Mr. Lamar to come out when you went out?
When I went out, Mr. Lamar, he was behind me. He came out behind me. My daughter would have been coming out behind Mr. Lamar, but Dee Dee shut the door and closed my daughter in, prevent her to leave out.
So she wasn't sitting down anymore on the edge of the sofa?
Once I turned my back and the door closed, I don't know what happened.
So how do you know she was coming out behind Lamar if your back was turned and the last time you saw her, she was sitting on the edge of the couch?
Because she had got her ID and her bank card from Miss Shamir, and we was leaving. We was in the process of leaving out the door.
Well, but you just testified that she was still waiting on Shamir to come and bring her ID. So was she sitting waiting on Shamir, or had she gotten her ID and she was leaving out with you? Which one is it?
Once she was sitting down, waiting on Shamir, I was still in the doorway. So when Shamir came down the steps and handed my daughter her ID and bank card, that was all she was missing. So as I turned around and stepped out the door, Mr. Lamar is right there. He come behind me. My daughter should have been coming out behind Mr. Lamar.
Okay, so you said Lamar didn't know you had a weapon, correct?
Yes,
You said your clothes were covering it, correct?
yes.
And tell us again how your clothes cover it.
My shirt was over my gun and my weapon was inside my waistband of my pants.
And then your shirt was covering that.
Yes,
Okay, and so Mr. Reed grabbed your weapon from the holster while your shirt was covering it and he couldn't see it?
he grabbed my weapon out the holster when he grabbed me around my neck when he attacked me. So once he grabbed me up behind, he was behind me, he grabbed me around my neck. When I went back, my shirt went up. He seen I had a weapon. He was trying to take my weapon, trying to steal it from me, trying to rob me from my weapon.
He was trying to rob you?
Yes, once he saw I had a weapon, he wanted it. That's why he wanted to take it.
How do you know that's why he wanted to take it? How do you know he was trying to rob you?
He's a known robber.
And you've seen him rob someone before?
No, I haven't seen him. He's been charged with robbery.
You've seen him rob someone before?
I ask you to answer.
I think she's allowed to clarify the answer. Overruled.
Have you seen him rob someone before?
No.
Okay.
He was trying to rob me.
Okay. And you stated that when you got there, he was standing there calmly with your daughter Nene, right?
Yes, he was talking to my daughter.
Okay. And he allowed Nene to use your phone, his phone to call you so that you can come pick her up?
That was after he drugged my daughter, him and Michael Waters.
He allowed Nene to use his phone to call you, correct?
Yes.
Okay, and Ms. Rivers, you spoke with law enforcement on the date of this incident, correct?
Yes, I did. Me and my daughter went down to headquarters.
Okay, and when you spoke with law enforcement, you told them that you began firing because you heard shots coming at you. That was initially what you told them, correct?
No. I never fired my gun.
And you also stated that you were standing on the porch and that at the time you were standing on the porch, that Lamar actually grabbed Nene.
I was standing in
That's
the,
when you began firing.
no. I was standing in the doorway. Lamar was inside of the apartment. My daughter was inside of the apartment, sitting on the sofa. That's when Mr. Lamar grabbed my daughter's arm. When she was inside, I was on the 1 foot in and 1 foot out because the sofa was right in the doorway.
And you also You just stated that, well, how long after you made it out the door did Nene come out the door?
Nene bust out the door and said, "Mama, run."
Okay, but you also told law enforcement that they were beating on Nene while she was inside the home. But based on what you're testifying now, she bust out right after the shots were fired and you weren't in there that much longer before. So how were they beating on her and she was sitting on the edge of the couch and she bust out right behind you? When did the beating occur?
The beating occurred before the mom pulled up Michael Waters and my daughter. They was already fighting and stuff. Mr. Lamar assaulted my daughter with Mr. Waters before his mother came on scene or before I came on scene. They drugged my daughter out. They forcibly removed my daughter, Michael Waters, and
But you told
Mr. Morris.
But you told law enforcement that they were beating on her while you were outside with Mr. Morris. And you just testified that she came out, that she was actually on her way out right behind you. So, and earlier when your attorney asked you, you also said that they were beating on her right before the shooting started. So that's not right before the shooting started, because what you're testifying to now is that the beating occurred before you ever even got there.
My daughter was assaulted before I got there.
That's what you're testifying
Prosecutor
now.
allow witness to answer the question.
So I'm let her finish her answer and then you can follow up.
The
So,
altercation started before anybody arrived. Mr. Morris Lamar, he was sent over there to see what was going on. And he helped Michael assault my daughter, drug her out by her arms and her legs. That's how she got put out the apartment. I wasn't there to witness that. Mr. Lamar testified that he did that, him and Michael Waters. And also, Michael Waters also testified to that he seen the struggle and the gun went off during the struggle.
and your daughter never told you, and based on her testimony, she never said anybody other than her and Michael had a altercation, correct? Physical altercation, correct?
She said they.
She never said anybody beat her. You testified to that. She never testified that anyone beat her, even in the incident earlier in the day. She testified that Lamar brought her out, that Lamar, she said that he put his hands on her and brought her out of the home. But did she say that anybody else beat her?
I'm questioning the
As
relevance
you just
of
testified.
this.
Michael
Just pause,
Waters.
Mr. Rivers. Well, there's been an objection. The objection is to relevance as to the daughter's prior testimony. I'll overrule that objection to relevance. You can answer the question, Mr. Rivers.
Michael Waters and Mr. Morris Lamar Reed assaulted my daughter before I got there. That was before the mama came and the sisters came. I wasn't there. She told me.
So where exactly does the tussle occur?
The tussle occurred outside the door.
So just outside the door?
When I stepped down to the step, when the door closed, that was when they locked my daughter inside, and Mr. Lamar grabbed me by my neck. Once he grabbed me and he saw my weapon, he drew my weapon, and that's when the tussle started.
So you said that's when they locked the door and your daughter was sitting on the edge of the couch. So you saw earlier, we had the pictures up and it showed the inside of the home. And the couch is right at the door. So if she was right at the door, you were just outside of it, Lamar was coming out of it, how was someone able to get in between all three of you all to close and lock the door?
They waited until I turned my back to proceed to walk down the steps. Mr. Lamar came directly behind me. So that's when the door slammed. My daughter never made it out.
So someone got in front of her, right in front of that couch? How do you know your daughter's not the person that closed the door? If the door closed behind you.
I asked for speculation.
Ms. Willingham, you're asking her to testify to something that's inside the house she didn't see?
Judge, she's testified that her daughter was coming out the door behind her. So I'm asking her how she knew that her daughter, if her daughter's coming out behind her, how does she know who closed the door behind her?
She's asking her to speculate, Judge.
Okay, well, I think if the question is just, does she know who closed the door behind her? That's a valid question. You can proceed, Ms. Willingham.
You keep testifying they closed the door. Do you know who closed the door behind you?
My daughter said Dee closed the door.
Did you see who closed the door behind you?
I heard the door close. I didn't see who closed the door. I know my daughter was still inside the apartment when the door closed.
And you testified that after the shooting, you left your daughter and your grandchild. How scared were you to do that?
My daughter wasn't close. She ran through the woods. She was running for her life. I barely made it in my car.
And how old was your grandchild at the time?
8 months.
And was he able to run?
A neighbor was holding him. My daughter had to leave him too when she ran.
So you were so scared that you left the daughter and the grandchild that you went to go get.
Ask and answer, Judge.
Overruled.
Yes, I was in fear of my life. We all was going to die.
Nothing further.
You redirect.
Ms. Rivers,
Yes,
obviously the events of August 24th were a terrifying situation, correct?
yes, it was.
And until Morris Reed, did Morris Reed grab you from in front or behind? How did he grab you?
He grabbed me from behind.
And then is it your testimony, your shirt raised up exposing the weapon?
Yes,
All righty. And would be your testimony that he immediately grabbed it?
yes, he did.
Does Mr. Reed have a reputation for taking other people's property?
Objection.
Yes, he
Wait,
did.
hold up, Ms. Rivers. On grounds of,
I'm sorry?
Relevant.
Ms. Willingham, basis of the objection?
Relevance.
Well,
Well, Miss Willingham had asked her before why she thought.
yeah, no, I think this is going to be, this line of testimony is foreclosed. I think on 404 grounds, this is objectionable, unless you want to try and rephrase or have some.
That's all right, I'll leave it
All
alone.
right.
Ms. Rivers,
Yes,
you were absolutely terrified and running for your life, weren't you?
yes.
Your daughter was terrified and
Objection.
running in another
Well,
direction for a while.
Wait,
right?
Mr. Treasurer, there's an objection. Mr. Willingham, what's the basis for the objection?
Leading.
All right, we can rephrase, Mr. Strasser.
Ms. Rivers,
Yes.
tell us about any emergency calls that you may have made as you were leaving the scene.
I made a call to 911. And when I got on the phone, I was telling them, shots fired, I need help, I need help. And I kept repeating shots fired, shots fired. They were asking me what was a cross street. I was saying that McDonough and Thomasville Boulevard, please send help. And I was telling them my daughter, I didn't know if she was dead. My grandbaby, I had no idea if they was dead or alive.
Oh, one other thing. The pistol, your firearm, the little Ruger concealed carry. Was it ever recovered?
No, my gun was stolen at the scene.
And you lost track of the firearm after Mr. Reed tackled you, right?
Yes.
I'll pass the witness.
Recross on those points, Ms. Willingham.
Nothing from the state.
All right, Mr. Rivers, you can step down. Mr. Strozier, does the defense have any other evidence or witnesses to call?
Defense rest, Judge.
Does the state have any evidence in rebuttal?
Judge, if we can just have a couple minutes to, I just want to, the state does have evidence in rebuttal. I just want to see, I know that person was en route when we started earlier, so I just want to see if they're here.
All right, let's take 10 minutes, members of the jury. Thank you.
All right, jury. Just clear, yeah.
All right, let's hold in place until we get an update from the state here. We're just going to hold in place until you give us some kind of a logistical update.
Actually here, Judge.
Okay, and so she did say a witness was here.
It is Morris Reed.
Morris Reed is here, and does this? How many witnesses does the state anticipate calling in rebuttal?
Just one.
Just Mr. Reed. All right, and he is here.
Yes.
All right, and since I gave just made the jury go out, I want to give them at least that 5 to 10 minutes, unless the state needs a break. I wanted to have some kind of preliminary questions about the charge because we're trying to get everyone a consolidated version so we can have a proper charge conference. I combined all the charges that both sides submitted, and I think they're more so on the defense side, maybe a number here that may not be as relevant to the case, and I wanted to make sure I understood exactly what the defense was asking for. So, Mr. Strozier, specifically on the lines of lesser includeds or some of the justification defenses, is the defense asking for a voluntary or lesser includeds of some kind? All right. And what about affirmative defenses such as accident, self-defense, that sort of thing? Are those being requested?
Yes, sir.
And which ones exactly?
You said accident or self-defense, that'd be both of them I'd request.
All right. And we can talk through this more at the charge conference. I just want to make sure we're on the same page. So with accident, my understanding would be that that's going to be if the defendant themselves is saying that the weapon discharged while it was under their control and that they played a role in an accident happening. I don't know if that's what I heard from Ms. Rivers, but again, I want to make sure I'm not taking away an alternative argument of yours or something like that.
Her position is the weapon was not under her control.
And so how do you think the accident defense would be relevant or play in here?
Well, I mean, it happened because there was a spike for the gun.
Okay, something we'll take up at the charge conference. And then same with self-defense, that's something you're asking for in this case as well?
Yes, sir. Well, I mean, yeah, she was trying to maintain control of her firearm. She just wasn't saying, she wasn't trying to get her firearm stolen from her. I mean, it's a natural reaction if you carry a firearm, somebody tries to tries to strong arm rob you of it, if you're gonna try to maintain control of it.
All right.
Yeah.
No, understood, Mr. Strozier. I'm just trying to, again, I'm trying to print out a collective copy, and I think there were just a few that didn't seem as applicable anymore.
Bottles of water available here.
Yeah, we can get you some water.
Well,
If we could get out a couple bottles of water. All right, I'll just note this generally. I think there's a number of defense requests that were not the current pattern charges or that had been replaced. I'm looking at especially a lot of evidentiary ones. So for example, impeachment of witnesses or prior inconsistent statements, they were a prior version of the patterns. They weren't the most recent. So I'm just going to print out what I have, and let me ask you this, because this may save some pages. Voluntariness or circumstances of the statement. It doesn't sound like the state is actually introducing her custodial statement. They just crossed her on it. Do we need those jury charges on voluntariness and that relate to custodial statements? Okay. All right. I will, we'll strike a few of these out, referencing that, give you a consolidated charge, and then does everyone still need about 5 minutes before we bring back the jury?
Yes, Judge.
Okay.
I just give me a bottle of water and I'm ready to go.
We will do that as well. Let's pick it back up at 10:45. I'm just going to stay out here on the bench, but we'll be formally in recess for the next 5 minutes. Thanks. Sometimes I guess license is slow in the afternoon. I wonder if it's a new one or.
Not in here.
Okay, so 13710, yeah, good character of the evidence. Yeah, yeah, so.
CBC.
All right, and picking it back up.
That's on your picture.
Yeah. So now I'm on intent, no presumption. We don't need parties to a crime, 23. We are back on the record. State ready to proceed? Ms. Willingham? Is the state ready to proceed?
Yes, Judge.
All right, Mr. Strozier?
Yes.
All right, if we could bring back the jury.
All right, so the jury. Here's the present judge.
Thank you, Deputy Scott. All right, the members of the jury, the defense is rested. And now I'll ask the state if they have any evidence they wish to introduce in rebuttal.
Yes, Your Honor. The state would call Morris Reed.
All right, if we could bring that witness forward, and we'll re-swear him in since he was previously excused.
Thank you.
Raise your right hand. Do you swear or affirm that the testimony should be the help you? Yes, sir. Then you see it. State and spell your first and last name for the court.
Yes,
You could state and spell your last name again for the record, sir.
yes, Morris Reed, Morris, Reed, Reed.
Good morning, Ms. Reed.
Good morning.
Ms. Reed, what do you do for a living?
I do mortuary work.
I couldn't hear that response.
I do mortuary work, sir.
And Mr. Reed, are you known in the community for stealing things from people?
No, I never stole anything from anyone. Most of the time, mostly helped everyone in the neighborhood.
And you said you do mortuary work. How long have you done that?
20 years.
And Mr. Reed, you testified last week in reference to where you were and where the defendant was from the start of her getting there up until this incident happened. So can you tell me, where was the defendant when this shooting occurred?
We was outside.
And had you all been into the apartment at all?
No,
So you didn't go in after she got there, and she didn't go in after?
No.
she got there.
no,
And you all remained outside in the front of the apartment?
yes.
And who was inside the apartment?
It was Drew, Nene, Miss Keisha, and Dee Dee.
And was the door open at any point where you could see where Nene was?
No,
And Mr. Reed, you were released from your subpoena last week, correct?
yes, ma'am.
And have you been watching the rest of this case from home?
Yes, ma'am. I've been watching it on Zoom.
And is there anything that you heard that did not line up with what happened that day?
There's a lot of things did not line up. I seen on Zoom.
So let's start with Ms. Rivers. What did you hear that doesn't line up with what you saw?
Me and her did not enter the house. We did not go into the house. And I did not pull Nene out by her hair or by her legs or by her ankles. Drew only asked me to pull her out by her wrist. I got her by her wrist. He grabbed her by the waist. We took her out. We walked down the sidewalk and we talked. That's all. Everything else about me and Miss Rivers going in the house, we did not go in the house. She shot in that house. Only thing I want to ask her, why did she pull that pistol out? Because everything was calm. Wasn't nothing else going on. Nothing. Only thing I want to ask her, why did she pull that pistol out? And she said, I ought to shoot through this woman, and that's what she exactly did. If she would have did what she had to do, well, none of us be sitting in this courtroom. If she would just got her daughter, got her stuff, and left. But I don't know why this lady turned from 100 to 1,000. She caused all this, and she know this. Only thing she do just prove she did it. That's all. When none of us be sitting in here, and she know this.
Thank you.
Cross, Mr. Strozier.
Mr. Reed,
Yes, sir.
you testified that you, forcibly removed Mimi from that apartment, correct?
Yes, because I was asked to.
Did she ask you?
No, Drew asked me because she was outrageous.
So you put your hands on her without her consent, right?
Yes, she told me to do it. And he told me to pull her out the house. We pulled her out the house together.
Mimi told you to put your hands on her?
Hey, yes, he did.
Okay.
Because me and her talked. I told her to come on. And me and her talked for a long time. And I don't know why she said that me and Drew pulled her out her house by her ankles and by her hair. That's not true.
Why do you think Michael Waters would testify that he saw you shooting a gun?
No, that's not true. I wasn't shooting no gun.
Uh, could you explain to us why you saw fit to put your hands on Miss Rivers, Andrea Rivers, my client? Why would you put your hands on her?
How can I tackle two people? Look how small I am. How can I tackle two people? Miss Rivers shot in the house first. After she shot in the house, that's when I grabbed Miss Rivers. Me and Miss Rivers were fighting over the gun. I never had control of the gun, period. Until we got out to the car, until Nene had me in the back of the neck, holding me down. After her mother said she should shoot me in the head.
Fact of the matter is, the gun's never been recovered, has it?
I don't know where's that.
You don't have it?
No, why should I have it? You got it?
Well, the testimony is that you tried to take it.
No, you got it.
Mr. Reed, if you listen to the question asked and only answer the question asked.
All right. Mr. Reed, isn't it true that you tried to take Miss Rivers' weapon from her?
No, we was fighting over the weapon, sir. Some kind of way the weapon went out into the street. After the shooting was going on, she jumped in her car and fled.
All right, no further questions.
Can you redirect Ms. Willingham?
Nothing.
All right, Mr. Reed, you can step down.
I gotta go back to work.
Any further evidence in rebuttal, Ms. Willingham?
Your Honor, the state would call one more witness and that'll be all.
All right. First thing I want to do is, as Mr. Reed was departing the witness stand, I think I heard him mumble something, but I couldn't make out what it was. And I'm curious if any members of the jury heard him mumble anything. All right. And sir, if you could identify yourself by your jury number. 33, what did you happen to hear Mr. Reed say? Okay. I just didn't know whether he was commenting on the evidence. All right. But just generally, I want to instruct the jury that whatever the witnesses say during their testimony is the evidence that you're to consider, not anything else they share with you or gestures they make. All right. State has an additional witness.
Michael Waters.
You swear for that the testimony should be brought is the truth and nothing but the truth of all you. First and last name for court.
Michael Waters, Michealwaters.
Good morning, Michael.
Good morning.
I just have a few questions for you. Have you been in the courtroom all morning?
Yes, ma'am.
And you heard the defendant testify, correct?
Yes.
Michael, has there been a incident where you were present and the defendant pulled out her firearm?
Yes.
Can you tell us about that incident?
One time she took us to get like a bed,
When you say us, who are you referring to?
me and Nene, or me and Trinikia. And when she got it, when she called her mom came and we went down to Moreland Plaza, and I think it was Maxway, Goodwill, whatever, which one was in that plaza. And basically, like, when we was in the plaza leaving and stuff like that, our car was trying to go around us. And Miss Andrea, she had got mad at the car for trying to go around her, and she shot her gun out the window like two times at the car.
And you were in here earlier, so did you also hear the testimony in reference to when you and Lamar got Nene out of the home?
Yes.
Did you drag her out?
No.
Did Lamar drag her out?
No.
Just 1 second. Michael, I am showing you what will be marked as State's Exhibit 110. You recognize that photo?
Yes.
And I'm sorry, do you recognize the person in that photo?
Yes.
How?
I always buy her weapon sometime,
I couldn't hear his answer.
I'm sorry, how do you recognize the person?
because I know who she is.
Okay, and who's that a photo of?
Andrea.
Okay, and is it a fair and accurate depiction of Ms. Rivers?
Yes.
The state would move to admit State's Exhibit 110.
I would object. We don't know who took that picture or when it was taken or for what purpose.
All right. And Mr. Willingham, I think I would like a little more foundation of where this photo comes from, or if he can tell us more about what it is and how it purports. Well, we'll get there, or unless you want to respond to that.
Relevant, Your Honor, the defendant testified to how.
Not so much the relevance, the authentication aspect of it.
Okay. How long have you known Ms. Rivers, Michael?
I wouldn't really say I know her for real at all.
When did you first meet her?
When we had went to get the bed, and I known Nene probably for already a year before I met her mom.
Okay, and when did you all, what year was that you all went to get the bed?
21.
Okay, and had you seen her anymore since you went to get the bed, but before the incident you're here for today?
One other time when Nene had some food stamps, she had came, but other than that, she wasn't no mother to her. So those was the only 2 times I ever saw Miss Rivers, and then the baby shower.
And when was the baby shower?
I don't recall the exact date.
Okay, and when you seen her, did you see her up close? Did you have actual interactions with her? Did you just see her like from afar in passing?
Probably just up and close, walking past, something like that. We never had no hey, goodbye, like relationship.
Michael, are you familiar with Ms. Rivers' social media?
Yes.
Okay.
I see Exhibit 110, Ms. Willingham.
Yes, Judge.
Okay, they have it right now.
You can look at the one on my phone. I mean, on the laptop. It'll be the same, it's just a different.
Are you retendering Exhibit 110 at this time?
I am, Judge.
All right, and so, Mr. Strozier, are you renewing the objections or?
I mean, there's a picture on somebody's telephone. Whose telephone is it?
All right, and so that'd be the authentication, and then it was also to relevance.
Yes, I got question the relevance. I mean,
All right, so Ms. Willingham, anything you want to address on the relevance objection?
Judge, as to relevance, the defendant testified earlier as to how she wears her firearm. And in this photo, it shows, how it's worn.
Okay, all right, based on my review of 110, I do believe it would satisfy that objection, so I'd overrule on relevance. And as to authentication, Ms. Willingham, any other thoughts you want to make on that?
Judge, if I need to go a little further, I can show it to the witness on the phone and have him kind of walk through a few things on the phone that way. It's a better picture than what's on my laptop at the moment.
Are you saying you want him to look at a live website?
Photo. It's the same photo. But on the phone, you can see the entire thing. On the laptop, it's kind of.
When you say the entire thing, you mean like the screenshot?
Correct.
And
that is that's even what's on my laptop. It's just blown up right now, the way it's on the screen.
sure, but by way of proffer, this witness is not the one who located this on her social media or personally removed it or has seen it in the wild?
He has seen it on the social media.
Okay.
So that's why I wanted to show it.
All right, why don't we lay that foundation then?
And Michael, have you had an opportunity, you mentioned earlier that you're familiar with the defendant's social media.
Yes.
Do you recognize the social media account that you see in this photo?
Yes.
And how do you recognize it?
By her name.
And what is that name?
Andrea Rivers 30.
And have you personally been on that social media account?
Yes.
And have you had the opportunity personally to go on that account and see this photo?
Yes.
All right, and you retendering it then at this time, Ms. Willingham?
Yes, Your Honor.
All right, defense's objections are noted for the record, but overruled the authentication and relevance objection. State's Exhibit 110 is admitted.
Permission to publish?
You may.
Sorry. And Michael, as we're getting that pulled up, that photo, could you see where the defendant was wearing, her firearm?
In her room.
I'm sorry, on her person?
Oh, yeah, in her waist.
And was it covered at all?
No. Her firearm never be covered.
Judge, I need permission to share the screen.
All right, and which username are you using, Ms.
It's under
Christian?
mine,
Okay.
Willingham.
If we could get Ms. Willingham added as a co-host.
And Michael, is that how you mentioned before that you have seen the defendant pull out the firearm? Is that how you've seen her wear her firearm before?
All the time I ever seen them.
And is it covered up by her t-shirt?
No.
Is it usually covered up by her t-shirt?
No, it's gonna be the exact same way in the picture. It's gonna be tucked and it's gonna be shown.
Thank you.
Cross-examination.
Mr. Waters.
Yes.
You have a pretty lengthy history of domestic problems with Mimi, right?
Objection.
No.
Oh, well.
It's always
Mr. Waters,
talking.
hey, I'm still here. Wait. Ms. Willingham.
Relevance.
That's why my client testified that she had to go over that day, Judge. It is relevant.
And it's beyond the scope, Your Honor.
All right, so Mr. Strozier, I think you can explore issues that happened that day. I didn't hear any testimony that made the entire history, to the extent it exists, if any, relevant.
My client testified to it, Judge.
She testified to needing to go over there because of the incident that day, and so I think that's what you're allowed to
She
explore.
was reluctant because they'd had a history of domestic violence and going right back together, Judge.
Ms. Willingham?
Judge, it's still beyond the scope. Nene is not the listed victim in this case either. And to get into that conversation, Nene would also have to be one of either the listed victim or the defendant in this case. And she's neither of those. So I don't know that we get into that aspect of this line of questioning. He's not on trial.
All right, Mr. Strozier, why don't we start with, I'll like to explore anything that happened the day of, and if you reach anything before that, we'll see where we are.
Okay. You and Mimi had a physical fight on that morning, didn't you?
I say arguing.
In fact, you broke her telephone, didn't you?
No.
She testified that you broke her telephone. Was she lying?
Yes.
You testified earlier that when you came out the door of the apartment, that you saw Morris Reed in control of the gun. Did you not?
I say I pretty much seen Ms. Rivers had majority of it. She upped her own gun.
Can you repeat that, please?
She raised her own gun.
You testified earlier that Mr. Reed had control of the gun.
She upped her own gun. That's why Mr. Reed said he was trying to fight with her from shooting.
In fact, the gun went off when they were fighting over it, correct?
The gun went off because Ms. Rivers pulled the trigger.
I'll pass the witness.
Nothing further.
All right, you can step down, Mr. Waters.
The state would rest.
I would like to call Mr. Rivers for rebuttal purposes, Judge.
You for a sir rebuttal?
Huh?
I don't think we can go back and forth all day, so I think we need to explore exactly if a sir rebuttal is, I guess.
Brief, Judge.
All right, Ms. Willingham.
Can we approach?
Well, no, I think we have
Just talk
to
about it.
just keep doing it. So, members of the jury, let's take 5 and need to address some things outside of your presence.
I rise for the jury.
Judge, it would be
Yes, Ms. Willingham.
it's the state's burden, so the state gets the last word.
Yeah, I
Not
can't.
sure. I
I
didn't
can't say I've
have
ever had this come up before, ever.
Not either, so.
So I have only, Mr. Strozier, ever heard or seen it that it's state defense and then state gets the right of rebuttal. I haven't heard or seen before that the defense can then come back and do another rebuttal, which then may subject the state to going again, which means it may go on forever. I mean, I think we've got to have a stopping point at some point. Do you have any, I don't know, you can direct me to some.
3 questions and 5 and less than 5 minutes.
It really has nothing. I mean, and feel free to, I want you to proffer if you want to make your record. And it's really not so much the length at all. I think you've been more than efficient, more than on top of it and concise. It's more just kind of procedurally. I don't even know if the defense has the right to do that again.
I believe I do, but I don't, I mean, I don't have time to just run out and research it in 30 seconds.
Mm-hmm.
So,
All right. Why don't you?
I mean, I'm gonna have to bow to you. You're a smarter lawyer and more learned than me.
Well, you've been doing this longer, Mr. Strozier, so I know you've seen some things that I probably haven't, but we'll see what we have here. Why don't you tell me just generally and proffer for the record what it is, these, 3 to 5 questions that you wanted to get into?
How she wears the pistol and what was Mr. Reed stronger, more powerful than her and able to wrestle control the weapon from her? That's all I want to know. That's all I want to bring out.
Those two topics.
Yeah.
Okay.
And not extensive at all. I think it's important and germane. I'm not going on a fishing expedition.
I know, I understand, Mr. Strozier, and I don't think you are either. But again, it's more just a matter of procedure. And are these things that, for one, I think she's already kind of addressed the first about how she wears a pistol. She testified to it fairly definitively. The issue of, her opinion of whether someone was more powerful or not. Again, maybe that's more kind of corroborating. I think, I don't know if that at this point.
He testified he was a little guy, wasn't very strong.
Yeah. And these are things I think the jury is just we're not going to have the push-up contest here, right, in front of everybody. That's something the jury just gets to make their determinations on their own. I don't see as just each other's characterization of that is going to have much of a material weight on it. So frankly, I think even rebuttal itself is generally something that comes down to the trial court's discretion. And if it's solely those 2 issues, Mr. Strozier, I'm not seeing, even presuming there is a way to allow it to keep ping-ponging back and forth, If it's just those two topics, I'm not saying that being enough to reopen the defense case.
What's that, James?
Mr. Reed had testified that he did not know my client had a weapon. I just want to clear that up.
And that would be cleared up how?
By making him tell us when he first realized she had a weapon.
So that's going to be through the testimony of Mr. Reed?
I tell
Okay.
you what, Judge, we'll just leave it alone.
All right. I think at some point, you know, we do get
I'll
only
cover
one
it.
bite at the apple, and we take that up in summarizing the evidence. So I think with that, then we will call the jury back in and we'll excuse them to lunch until 1 o'clock. I think I would anticipate we could handle a charge conference in the next 30 minutes, and then we'd be ready to go with closings at around 1 o'clock. It's 11:20. And so that'd be a full hour for lunch, and we can come back at closings or if you need more time to prepare for closings, I'm willing to hear it.
No.
Okay.
I think everybody's interest would be best served if we move forward as rapidly as possible.
Ms. Willingham, anything you want to add?
Nothing from the state?
I mean, I don't have any problem giving the jury 30 minutes and having a charge conference and starting right back up.
Well, I appreciate the eagerness, Mr. Strozier, but I think the afternoon's going to give us enough time to do what we need to do. And so let's call the jury back in. We'll excuse them till 1 o'clock.
Rise for the jury. Present, Your Honor.
Thank you, Deputy Scott. All right, members of the jury, at this point, the evidence is closed in this case. Both the state and the defense have rested. And so what's left for us to do is we still have some things now we need to do outside of your presence to get everyone ready for closing arguments. That takes a little bit of time, and then we would be able to roll into closing arguments. And because we're right up upon our lunch break, the idea is that we'll excuse you for a little bit longer of a lunch break than usual. We'll have you back here at 1 o'clock, ready to begin closing arguments. Just again, as an expectation of what's ahead for the rest of today, by law, each side has allotted 2 hours to give a closing argument. Generally speaking, the parties don't have to use all that time, but they could, just so you know. And then at the conclusion of closing arguments, that's when I charge you on the law. That takes about 15 to 20 minutes. And from there, seeing where we are in the day, that's when we would have you retire to the jury room, and you can begin your deliberations at that point. We'll talk you through a lot more of what that looks like and how that works at the charge conference. But for now, will be excused. You will be excused until 1 o'clock. Remember, no talking about the case until we've gotten through closings and the charge, meaning deliberations. And don't do any research about this case except what you learn in this jury room. All right, you can stay here. You can leave the building. We'll see you at 1 o'clock.
All rise for the jury.
Ms. Smith.
What's it, 3? Just clear, y'all.
Good. All right, so at this point, let's move into our charge conference. I have marked as Courts Exhibit 3 a consolidated version of the state and defense request to charge. As
We don't have any. I mean, if you want to give us a blood draw, put it on here. That's fine. I didn't get to fix one.
So what?
I didn't get to fix you got stingy.
Oh, you say you did not?
No.
David, pick up where you that picture, mark it DE1 and give it to him.
You can have stickers.
Huh?
I have stickers.
Okay, that work.
I have to send stickers, but I need the one that you show. Was it one or two of them?
Just one.
Yeah, I just need the one that you showed and you put this on there and put the one on there.
DE1, don't you?
Put it to the bottom.
Huh?
Very nice.
All you have to do is put one right there, because it's already, you already said. But just take out the certificate, that one. Put one.
I put it on.
About to close.
Mm-hmm.
She test.
Mm-hmm.
Oh my God, I'm about to hear about that. What time? They closing at?
What? Someone has done a potential suggestion. Because he said, it might be a little after one, so I don't know.
He told you to come back at one.
Well, he said so. That I can make sure I think you do have some people who figure out that yes.
I see.
Mm-hmm.
I was running you, cause I'm thinking, I was late.
There's no such thing. I knew I missed something. I was said that, it was free said that. There's no such thing.
Mhm.
And then I got, wait, no, today the first.
Does he have, I think we got some on Wednesday. Wednesday, May. We May.
There's no damn other day you do this. Yeah.
Yeah.
Part of the day.
What's wrong with you and Reed?
So.
I know y'all got people.
Because, yeah, I've been asking.
Mhm. Mm.
Number two.
You don't see nothing. Mm.
Here, right.
Yeah. Yeah.
Supposedly Patrick is a definite go. I don't trust Barry because I think that's a child. That's a. I think Cofield, that's all the child. Patrick is an SVU case. I could go. I'm ready. I mean, if they wanted to bump me up first, and I've seen him do stuff like that. Supposedly Patrick is the one that's ready, so we'll see. I know what he'll think though. I'll tell him it's gonna take us 3 days, 3, 4 days. He's gonna say, well, I'm already having my case going. He wouldn't want to do mine. I just know how. Me too, July 15th. What, but I think I'm.
What kind of website?
Girl, shut your mouth. I'm sitting up here trying to worry about doing the case, saying that you just go ahead and do them.
That was stupid.
Oh, you have something on the mind. And just keep them.
Now.
Hey, how are you? I spoke to my supervisor. You probably won't like my. No. But let me try to get back. We would dismiss felony murders, all of the felony murders. We would even dismiss the aggravated assault and the deadly weapon. He would have to plead to these drug charges. He would have to plead to all the drug charges.
All right, we're not back on the record yet, but before we are, Ms. Sue is passing out the finalized version, so y'all can take a look through these jury charges and take as much time as you need. We want to make sure nothing slips through. And as you're doing that, also a verdict form. Did we get him a verdict form to look at? Okay. Thank you. Okay, as they're taking a look through the charges, Ms. Russell, what are we doing on Mr. Coleman today?
Your Honor, counsel is back talking to this client. We had so it wasn't filed, but last time Mr. Sterling asked for a motion for bond. I know he wasn't going for it on the immunity, but he asked for a bond. The family is here and we could go for it on that if Your Honor is, once will allow us to. I understand you all have other matters.
So you're saying that you don't have any concerns with going forward with a bond motion, even though one wasn't filed?
I don't have one, Your
All
Honor.
right.
Because he'll end up filing it and it'll be placed back on the calendar again.
Sure. All right. And has he been back there for a while?
Has not, Your Honor,
Okay.
probably even a minute before you came on.
Is there a way, Deputy Scott, I wonder if we can have him exit through Judge Richardson's courtroom, or because if we go ahead and get started with closings, maybe we could take it back up in about an hour and a half.
I'll be
I mean,
here.
everyone's already here. If they're willing to wait, we could see where we are, especially if he might still be talking with his client for 15 or 20 minutes. I don't know.
Absolutely.
Okay. Well, let's do that. So, yeah, Deputy Scott, if you could tell Mr. Sterling he can be back there as long as he wants. And when he's done, just to exit out the other door. And then we'll take it back up. Maybe we'll give you a call whenever we're done with closings.
Thank you, Your Honor.
All right. And y'all just give me a head nod when we want to go back on the record and make sure we're good with this charge. Oh, great. Perfect. This will be one for me to write on. You want one? Okay. Yeah, one. Okay. All right, let's go back on the record with State versus Andrea Rivers. State is present, counsel is present along with Ms. Rivers. I have provided counsel with Courts Exhibit 4, which will be a consolidated version of the charges that we went over during the charge conference. I've also provided them with a verdict form, which lists the 8 counts with a not guilty and guilty option for each. There are no lesser included options requested. And so starting with the state, have you had enough time and do you have any things to raise about the charge of the jury that I've provided you? All right, Mr. Strozier? Any concerns with the verdict form? Ms. Smith, there's the board.
Verdict form signed, Judge.
All right, then is there any reason we should not call back in the jury, Ms. Willingham? And do we need to get you to share your screen here? You have your capabilities? Ms. Willingham has I think a PowerPoint that she's going to use during her closing, so I'm making sure she doesn't have any technical issues here before we bring them back.
Before you came in, so
If you need to go ahead and pull it up now, just to make sure you can. And then the last thing I would just note is I'll have, be keeping track of the time on the wall clocks here with the state in red and the defense in blue. And I've got 2 hours up there for each. And I take it the state is doing an opening and closing. Okay. All right. Well, then with that, Deputy Scott, if you could bring back in the jury. Thank you, Deputy Scott. Members of the jury, welcome back, and thank you again, as always, for being on time and ready to go while we finished up a few matters to get things ready for you. So as I mentioned before, we are now ready to begin closing arguments, and the state has the right to begin those closing arguments. Ms. Willingham, is the state ready?
Take ready.
All right, the floor is yours.
Good afternoon, ladies and gentlemen. You all have sat with us for a week and a little bit of change. I came up here last week and I told you all that at the end, I'd come back to you and I would explain to you again why you should find the defendant, Andre Rivers, guilty of all charges. So that's what I'm here to do today. Ladies and gentlemen, you as the jury have a duty. And that duty varies for it. You all have a duty to follow the law. You have a duty to be fair and impartial, honestly seeking the truth. And you are not to seek doubt. You are bound by the instructions and the law that will be given to you. You all go back and prepare to deliberate. The judge, as we told you earlier, is going to give you law at the end of this. I'll talk about some of that law as I proceed forward this afternoon. But ultimately, the judge will give you the law. And you have a duty to follow that law that he provides to you. Sorry about that, I'm going backwards. Ladies and gentlemen, you also have a duty to deliberate. When you all go in that room, every juror must deliberate. If you all find that one of your peers is not participating in that deliberation, you have a duty to let the judge know and bring it to the judge's attention so that you can make sure that you all are following your duty. As we've mentioned, it is a very important job that you all have. So important that we ask you to be here with us for a week and a little longer. Ladies and gentlemen, Within that circle, you see the things that you all have a duty to consider. Statements, expert testimony, the testimony of the victim, photos and documents that you all will receive. Common sense, your common sense, ladies and gentlemen. Use your common sense based on what you've heard, all of the witnesses testified to. You now have a duty to use your common sense and listen to the testimony of the witnesses that you all heard. You'll consider that. You'll make sure that you pay attention to the elements of the crime that we'll go over a little bit more. Ladies and gentlemen, what you are not to consider are the things outside of that box. Passion, public opinion, sympathy for the defendant, being unhappy with the police, public's feelings, sympathy for the defendant, prejudice, disagreeing with the law, penalty and punishment. Those aren't things that you all are here to consider. What you are here to consider is the evidence that was presented in this case, the evidence that you all will have the opportunity to take back with you and review. Ladies and gentlemen, it's not your job to consider what will happen to the defendant when this case is over. It's just your duty to consider what the law says and whether or not you believe the defendant is guilty. Ladies and gentlemen, the state has the burden of proof. That burden lies with us. It never transfers to the defendant. It stays with the state. Burden rests with the state to prove every essential element of the crime charged beyond a reasonable doubt. Ladies and gentlemen, as we discussed at the beginning of this, you have several crimes that you'll consider here. 2 counts of felony murder, 4 counts of aggravated assault with a deadly weapon, 1 count of criminal damage to property in the first degree, and possession of a firearm during the commission of a felony. Ladies and gentlemen, as I discussed, that burden does not shift to the defendant at any point. The defendant, there's a presumption of innocence. Legal presumption until the state proves, so until we prove beyond a reasonable doubt, which I submit to you, we have done. This does not mean the defendant is actually innocent. So, ladies and gentlemen, having a reasonable doubt, we are holding you to a reasonable person standard. Reasonable doubt means exactly what it says. Reasonable. Based upon common sense and reason. Your common sense, ladies and gentlemen. Not vague or arbitrary doubt. Doubt for which reason can be given. Not required. We are not required, ladies and gentlemen, to prove beyond. We are required to prove beyond a reasonable doubt. We're not required to prove beyond all doubt. Ladies and gentlemen, on this next slide, you are going to see what is missing a few puzzle pieces, but appears to be a dollar bill. We can see the $1 sign at the bottom. We can make out George Washington. So are there some pieces missing? Yes. But can you see that that is still a dollar bill? Even with those pieces missing. And ladies and gentlemen, that is what we are asking today. That even if you feel that there are a couple of pieces missing, if you can look and still be able to see that based on the evidence the state presented, that the defendant is guilty, then that is the burden that we are here today to prove to you. You all have heard testimony from several witnesses You've seen several photos, you've gotten to hear 911 calls. And ladies and gentlemen, that is the combination of direct and circumstantial evidence. Direct evidence is evidence that points immediately to the question of law. And I'm sorry, the question at issue. And a piece of direct evidence can be photographs, photos, documents. It can be eyewitness testimony. And ladies and gentlemen, you heard from Lamar or Morris Reed, as I called him, but you heard from several witnesses that they called him Lamar Morris Reed. And Morris Reed told you what happened that day. He told you what he saw. He was an eyewitness. That is direct evidence. He told you that he saw the defendant shoot the gun at Shamir's home. That is direct evidence. What Lamar saw. What he heard. Ladies and gentlemen, when he saw her shoot the gun, he heard the bullets. He told you that he heard her say she should shoot, and then she did. That is direct evidence. Lamar's testimony, that's what we just talked about. That is the direct evidence you have in this case. Ladies and gentlemen, the defendant told you herself that the gun went off. The gun went off, ladies and gentlemen. That, again, is direct evidence that at minimum, she had a firearm in her hand, which is a deadly weapon. And we'll get more into that as I get further into the law. Ladies and gentlemen, again, as I stated, you have Lamar's testimony. You have the defendant's statement that she made on the stand herself. Ladies and gentlemen, and then we'll talk about circumstantial evidence. In this case, there's been lots of circumstantial evidence. You heard from a lot of people who couldn't say for certain that the defendant was the person that fired the shots because they were already inside the home. However, you've heard from people who said that they saw the defendant and Lamar tussling over the firearm. The firearm that Lamar told you the defendant fired, and he then tried to get it out of her hand. And people then subsequently told you that they saw that same tussle that she herself said occurred. So you are to take the circumstantial evidence using the direct evidence that we just talked about to infer the other facts. So using Lamar's testimony that the defendant shot, using the defendant's daughter's testimony that as she came out of the home, running out, she hears shots. She sees Lamar tussling. So Lamar's testimony that that tussle happened after those shots, the defendant's daughter's testimony that that tussle happened as she was coming out of the home after hearing the shots. You, ladies and gentlemen, use reasonable and justified common sense to determine that that evidence leads you to the defendant. Ladies and gentlemen, in light of your life history, I want you to reasonably determine that the defendant is guilty. Circumstantial evidence, ladies and gentlemen, you don't have to rely on all of the only direct evidence in this case. You don't have to rely only on the circumstantial evidence because, again, Lamar saw the defendant shoot 3 times. He told you that. He said he stood outside, he saw the defendant shoot 3 times, and then he got off of the air conditioner unit to try and stop her. Lamar said that after the defendant shot, they began to tussle. Michael saw the defendant tussling with Lamar. Nene saw the defendant tussling with Lamar, and a reasonable conclusion is that Lamar was tussling with the defendant to get the gun out of her hand after she shot, which is what he also told you. Ladies and gentlemen, Shamir was standing by the window. You heard that from Miss Jordan, Shamir's mom. You heard that from Dee Dee, Shamir's sister. You heard that from Michael, Shamir's brother. Ladies and gentlemen, Nene also told you Shamir was standing near the window. Then you hear Lamar tell you that the defendant fired shots towards the home. A reasonable conclusion, ladies and gentlemen, is that that bullet, at least one of those bullets, because remember Lamar told you she shot 3 times, at least one of those bullets went through that window where Shamir was standing, inside a home where Michael was standing, where Miss Jordan was standing, where Demetria was standing. And that one of those bullets, unfortunately, killed Shamir. And ladies and gentlemen, that bullet came from the defendant's gun. Credibility of the witness. You all determine the credibility of the witnesses that you've heard from. You all get to make a decision as to whether or not you believed the witnesses were credible. You will take into consideration the manner in which the witnesses testified, interest or lack thereof, means and opportunity for knowledge of the facts. All of them told you they were there. One person told you they were actually outside at the time the shooting occurred. The nature of the facts, the probability or improbability, personal credibility as you observed it. You got to hear from each of these people. You got to see their demeanor as they were on the stand. So you get to take into consideration whether or not you feel them to be credible. Testimony of a single witness. Ladies and gentlemen, you heard from several witnesses, but there was one witness in particular who told you that the defendant is the person that shot the gun 3 times, told you the defendant is the first person they saw fire shots. Put all of this into motion, and that is Lamar. Ladies and gentlemen, the testimony of a single witness, if believed, is sufficient to establish a fact. Lamar's testimony is sufficient to establish the fact that the defendant fired 3 shots into Shamir Poole's home, subsequently killing her. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Again, Lamar told you, Nene and Michael corroborated what Lamar told you because they said that as Nene was running out of the home, after she hears the shots, that Lamar and the defendant were tussling over the firearm. Lamar said he began tussling with her after the shots, trying to stop her from firing any more, trying to get the gun out of her hand. Michael told you he saw Lamar and the defendant tussling over the very gun that had just fired 3 shots. Expert witnesses. Ladies and gentlemen, you got to hear from Dr. Karen Sullivan. She was the ME. She told you that Shamir was killed by 1 single gunshot wound to the head. The law permits an expert to give their opinions based upon their training and experience. When scientific, technical, or other specialized knowledge that might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter. Again, Dr. Sullivan, she gave you her resume. She told you her background. So you know that she's an expert. She told you that she has done more than 4,000 autopsies combined, considering her personally doing them as well as her overseeing them. She told you that she has been doing this since 2002. She told you that the manner in which Shamir Poole died was homicide by a single gunshot wound to the head. Identity. The state must prove the defendant's identity beyond a reasonable doubt. Ladies and gentlemen, Mark's over this whole thing. So that's not really something that you need to ask about, because he told you, he saw her shoot the gun. Nikki told you her mother came. Michael told you he saw the defendant out there with a gun. That's not up for question. Sympathy, ladies and gentlemen. You talked earlier about not having sympathy. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. Ladies and gentlemen, you heard from Shamir's siblings. You heard from her mother. And I know that they showed some emotion on the stand, but you're not to consider that. What you are to consider are the things that they said about that day. You are to consider what they heard, what they saw. You are to consider that Shamir Poole is dead because of the defendant. Ladies and gentlemen, intent does not mean that the defendant intended the result. Intent may be shown in many ways. It may be inferred from the proven circumstances or by acts and conduct, or it may be inferred from the natural and necessary consequences of the act. Ladies and gentlemen, the defendant did not have to intend to kill Shamir Poole. What she did have to intend to do was fire the shot, commit the aggravated assault that did kill Shamir Poole. What she did have to do was intend to shoot towards that home, act towards and in the direction of people that she knew was in the home. She knew that Michael was inside that home. She knew that Miss Jordan was inside that home. And she knew that Demetria and Shamir were inside that home. And she still fired shots that went through a window, causing the death of Shamir, who was standing in front of that window. That is the level of intent that you need to be looking at. It does not matter that she intended, whether she did or did not intend for Shamir to die. It matters that she intended to commit the act of the aggravated assault, and that she knew from shooting a firearm into a home where people were could result in Shamir's death. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply that intent to commit the act that is prohibited by statute. Criminal intent may be inferred from conduct before, during, and after the commission of the crime. Again, ladies and gentlemen, she pulled out a firearm. She intentionally pulled the trigger on that firearm 3 times. Whether she intended to damage Shamir's window, whether she intended for Shamir to be hit by the bullet that she shot through the window, whether she intended for Shamir to die, does not matter. What does matter is she intended to shoot into that. She intended to pull that trigger. And she should know that firing a gun into a home where people are could result in someone dying. Ladies and gentlemen, now I'm going to tell you what this is not. Justification and the use of force in defense of self. Ladies and gentlemen,
a defendant is justified in using force that is intended or likely to cause death or serious bodily injury when he reasonably believes that the use of such force is necessary to prevent the commission of a forcible felony, which means a felony that involves the use of force or violence against another. There's no justification, ladies and gentlemen, when the defendant provokes the threat or use of force against herself, intending to use that threat or force as an excuse to harm another person. The defendant is attempting to commit fleeing after committing a felony. And no justification when the defendant is the initial aggressor unless she withdraws from the encounter and clearly communicates to the other person her intent to withdraw, and the other person continues or threats to continue the use of unlawful force. Ladies and gentlemen, the defendant in this case was the first person to pull out the guns. There is no justification. You pull out the gun first. You fire the first shot, and you've heard that from Lamar. Ladies and gentlemen, the charges. We've talked about them a few times, but I'm here to remind you, the defendant is charged with felony murder. The basis of that first felony murder is aggravated assault with a deadly weapon. That is the aggravated assault that led to the death of Shamir Poole. Felony murder count 2 is the basis of that is criminal damage to property in the first degree. That is when she shot through the window, endangering another human life. That human life being Shamir Poole, Michael Waters, Demetria Poole, Keisha Jordan. Aggravated assault with a deadly weapon. Another count of aggravated assault with a deadly weapon. And these aggravated assaults, ladies and gentlemen, are for the people that I just named. Shamir Poole, Michael Waters, Demetria Poole, Keisha Jordan. Criminal damage to property in the first degree. We discussed that when we discussed the second count of felony murder. That's for her shooting into the home, endangering human life, that life being all of the people inside of that home. But that criminal damage goes with that felony murder, that second count of felony murder, because it also led to the death of Shamir. And ladies and gentlemen, possession of a firearm during the commission of a felony. The defendant told you she had a gun. She told you she had a gun. Lamar told you she committed these felonies. So we know that she's in possession of a firearm during the commission of a felony because Lamar told you she shot the gun and she told you she had the gun. Ladies and gentlemen, motive. The state's not required to prove motive. No proof of motive is required. Evidence of motive, if any, is admitted to show the state of the defendant's mind at the time of the crime. Ladies and gentlemen, she told you that she went over there to help her daughter. That was her intent when she got there. However, she ultimately ended up killing Shamir. We don't have to prove motive. Now let's go through the counts. Felony murder are counts 1 and 2 of this indictment. A person is guilty of felony murder when a homicide is committed during the commission of a felony. There must be a connection between the felony and the homicide. And with that, no proof of malice is required for felony murder. No express malice, no implied malice. No intent to even cause the death is required. We talked about that. She did not have to intend for Shamir to die. If the death occurred while the defendant was engaged in the performance of any felony act, it's felony murder. So when she fired that shot
That was aggravated assault. That is a felony. And that felony led to the death of Shamir. The defendant is involved in a felony. Someone other than the defendant dies, then the defendant is guilty of felony murder. Shamir died. The defendant was involved in a felony, and it led to Shamir's death. During the commission of aggravated assault, caused the death of Shamir Poole. That's the basis of your felony murder count for count 1. A person is guilty of aggravated assault when aggravated assault of another person with a deadly weapon. A person is guilty of aggravated assault. Let's break that down. Aggravated assault of another person. Defendant shot at, toward, and in the direction of Shamir Poole. Shamir was in the house. The defendant shot towards the house. So she shot at, toward, and in the direction of where Shamir Poole was, with the intent to cause a violent injury. Shooting a gun at, toward, and in the direction of Shamir's direction. It ultimately led to, unfortunately, shooting Shamir. And Shamir died from that. With a deadly weapon. How do we know the defendant possessed a deadly weapon? Lamar told you. She told you. Michael told you. The defendant said she shot the gun. She said she had the gun. She said she had it. Shamir was dead by a single gunshot wound to the head. The ME told you that, ladies. Dee Dee told you that. Dee Dee told you that her sister fell to the ground with a single gunshot to her head. Felony murder count 2. During the commission of criminal damage to property first degree, the defendant caused the death of Shamir Poole. Criminal damage to property in the first degree. A person is guilty of criminal damage to property in the first degree knowingly and without authority interferes with any property in a manner so as to endanger human life. Well, let's break that down. Knowingly and without authority. The defendant shot into the home without permission. It wasn't her home. You can't shoot into it. But she pulled out her firearm and she shot towards that home. That bullet went through that window. She damaged the window. We saw the photos where the window was damaged. We saw even on the curtains where you could see that the curtains were actually closed and the bullet went through, piercing even the curtains. You can see a little hole if you look back at those photos, which you'll be given, in a manner so as to endanger human life. By shooting through the window while Shamir, Michael, Keisha, and Demetria were inside. That is to endanger human life. To shoot into a home while people are there endangers human life. Aggravated assault with a deadly weapon. Now we'll walk through the aggravated assaults on Keisha, Demetria, Michael. And if you're gonna recognize, ladies and gentlemen, it's gonna be similar. The defendant shot at, toward, and in the direction of Demetria Poole, who was inside that home, with the intent to cause a violent injury, pointing a gun in Demetria's direction by shooting at, toward, and in the direction of Demetria Poole, with a deadly weapon. How do we know the defendant possessed a deadly weapon? We talked about it. Lamar saw her shoot the gun. He had to fight her to get the gun out of her hand. He tussled with her, trying to get that gun out of her hand to ensure that no one else was injured. Michael told you, the defendant told you. Count 5 is gonna be the aggravated assault on Keisha Jordan. That is Michael's mom. That's Shamir's mom. Same thing, ladies and gentlemen. She shot at, toward, and in the direction of Keisha Jordan, who was inside that home. She had no regards. We know she had the deadly weapon, ladies and gentlemen, because it's the firearm that Lamar told you. And the last count of aggravated assault will be for Michael Waters. Michael Waters was also inside that home when she shot at, toward, and in the direction of that home. And in shooting at, toward, and in the direction of Michael, she committed an aggravated assault with a deadly weapon. Again, we talked about the deadly weapon. Lamar saw her with it. She acknowledged she had it. Michael saw her with it. Her daughter told you she saw her with it. Possession of a firearm during the commission of a felony. We've gone through that. That is the fact that she had this firearm in her hand while she was shooting into the home, which was a felony in itself. And she, at that time, as she committed this aggravated assault, she had a firearm. It's a very straightforward charge. Did have within arm's reach a firearm during the commission of a felony. Those felonies are felony murder, aggravated assault, criminal damage to property in the first degree. And ladies and gentlemen, I ask that you find the defendant guilty of all charges. Thank you.
Whenever you're ready, Mr. Schroeder.
Good afternoon, ladies and gentlemen. The defense is aware that every one of you guys has paid really keen attention to the evidence, and for that, we are deeply appreciative. I'm going to keep my remarks brief. This case, it really isn't very complicated. But in the beginning, Ms. Willingham asked you guys to hang on to your common sense, and I want you to continue to do that. Ms. Willingham has the duty, or had the duty, to prove each and every element of each and every charge beyond a reasonable doubt. Ms. Willingham has not been able to meet this burden. This case boils down to who do you believe? Or do you believe anybody beyond a reasonable doubt? You heard from Mr. Reed, who appeared to be making things up on the fly and was a little bit amused. You know, when I confronted him about his activities and trying to disarm my client. You also heard from Michael Waters. Michael Waters first said when he came out that he saw Morris Reed firing the gun. Now later in rebuttal, after he's seen the trial and said and had opportunity to watch it, he comes back as a rebuttal witness and changes that a little bit, just like Morris Reed, changed a little bit of his testimony as he went. You also heard from Mimi, the daughter, and she said that she came out of the house that she saw Mr. Reed and her mother struggling for the gun. The shots went off. Ladies and gentlemen, you all, but more importantly than all of that, you heard from my client, a 46-year-old grandmother who's never been in any trouble in her life, who's lawfully carries a firearm for her protection and has done so for a long time. My client, Miss Rivers, could have hidden behind her attorney and just had me pick the case apart and sat there, but she wanted to face you guys. She wanted to face Miss Willingham, wanted to face her accusers and tell her side of what happened, exactly what happened. You also know from the testimony that my client arrived on scene with one intention and one intention only, and that was to get her daughter and grandbaby to a place of safety. Ladies and gentlemen, I would submit to you that based on the evidence presented, that it's really impossible to determine beyond a reasonable doubt how the gunfight started, but the best evidence suggests that the gunfight started because Morris Reed tried to take a gun from my client and she resisted his taking it. And in doing so, the gun went off. Now, I'm not trying to minimize this unspeakable tragedy in any way. Shamira Poole was a model citizen, a beautiful young woman and an asset to her family and community. And her death is an unspeakable tragedy. What I don't want to have happen here is compound this tragedy by convicting an innocent woman. My client did not initiate this gunfight. My client was only attempting to get her daughter and grandchild to a place of safety. I ask you people to hold on to your common sense and ask, what's more likely? Is it likely that Miss Rivers shot into a house where the state would have you believe her daughter or grandchild were still inside? Ladies and gentlemen, that doesn't make any sense whatsoever. In a few minutes, Ms. Willingham is going to get to speak with you again. That's the rules of the game. And once I sit down, you will not hear from me anymore. But I'm going to ask you to return to the jury room and fairly and completely deliberate the evidence in this case with the same keen interest that you've displayed all along, and then come back and render the only verdict that reflects justice in this case, and that is not guilty. Thank you, ladies and gentlemen.
Ladies and gentlemen, I'm going to tell you a story about sand in a bag. There is a Border Patrol agent, and every day that he's there, he's nearing the end of his time there, but every day that he's there, there's a boy that rides through with a bike. And in that bike, he has sand in that basket. And every day, that agent checks the basket looking for what the boy is smuggling in. And every day he finds nothing. So a year goes by, and each day he comes through on a red bike with sand in the basket. Each day, the agent finds nothing. As it comes time for the agent to retire, he says, I'm retiring. Today's my last day. You come through every day with this red bike and sand in this basket. What are you doing? And he says, you were checking the sand to see if I was bringing anything in. But really, it's the bike. I rode in with a new red bike every day. Ladies and gentlemen, I tell you that story because I don't want you to pay attention to the sand in the basket and miss the bike that's really being smuggled in. Ladies and gentlemen, the sand, the tussle with Lamar or Morris Reed. She says others were shooting as she was running. The defense attorney showed you a photo and said the car was shot up. But she really focused on that tussle with Mr. Reed. Ladies and gentlemen, that tussle is sand. All of those things, that's just sand. It's sand in the basket to distract you from what's really going on. Lamar, he told you he was there to help. Nene told you he came, walked her down, let her use his phone to call her mother to get help, to call her mother and ask her mother to come back or to come pick her up, pick her and her baby up. Lamar was just there to help. That's what he told you. He told you he's the person in the neighborhood that just tried to help everybody. He only approached her after she fired shots. He showed you in the photos where he was sitting on that air conditioner. He showed you where the defendant was standing. And he told you that the defendant pulled out her firearm and began to shoot into the home where Shamir, Michael, Keisha, and Demetria were. Her focusing, the defendant focusing, even when she testified on Mr. Reed, was just putting sand into the basket. She says she was shooting back. Ladies and gentlemen, she pulled the gun out first. Accident or self-defense, it's two different theories. Ladies and gentlemen, you've heard the defendant testify, you heard her attorney talk about how she was tussling with Lamar and the gun went off. But then she said that she was acting in self-defense trying to stop Lamar. Well, was she trying to stop Lamar from getting the gun? Did it accidentally go off? Which one was it? I'm a little confused. You should be too. She can't do both. The tussle with Lamar, Morris Reed, he was, as we talked about, he was there to help. He only approached her after she fired the shots and the defendant pulled out the gun. Therefore, she's still guilty. She set all of this into motion when she pulled out that gun from her holster. Ladies and gentlemen, you saw the photo of how she actually wears her holster. It's on the outside. So it was there. If Lamar wanted to take it, he could have taken it before she shot. He told you he took it when she fired shots. Her daughter told you that she heard the shots as she was running out. And then she saw her mom and Lamar tussle. Others were shooting. Lamar saw her shoot first. Michael saw her with a gun in her hand. 911 calls say she was shot say she's the one that shot into the house.
I just told them that they was gonna shoot, man. These motherfuckers don't never fuck. Yes. Yes. After school and I seen this lady shoot my next door neighbor.
All three parts of that call. He says, I told them she was gonna shoot. She was gonna shoot. Not he. I told you she was gonna, or I told them she was gonna shoot. Dee says, she just shot my neighbor. This lady just shot my neighbor. This lady. Not this man, not Lamar. The neighborhood knew Lamar. Lamar told you that. This lady.
Yes. Yes. I went to school and I seen this lady shoot my neighbor's door neighbor. Them that lady go shoot, man. These motherfuckers don't never fucking.
Her car was shot up. Ladies and gentlemen, Dee Dee told you that she shot out the door after she saw that her sister Shamir was shot in the head. Michael said he went into the street and shot after his sister Shamir was shot in the head. Lamar told you the first person he saw shoot was the defendant. Ladies and gentlemen, I'm not here to argue with you about I'm not here to argue whether or not the defendant's car was shot into. I'm not. She told you it was. You're gonna see photos that it was. The photos that defense got in through her. You will see that yes, her car was shot. But that happened after Shamir was laying lifeless on the floor of her home as her sister held her. She recognized her sister was gone. She still heard shots, so she fired back. Dee Dee told you that herself. Michael told you himself that yes, I went out and shot after my sister was on the floor dead. After Lamar told you the defendant fired shots. Miss Jordan told you she had to jump over to get to the kitchen to try and get help. She told you she used a new t-shirt to try and stop her daughter from bleeding out of her head. And that all occurred before the defendant's car was shot into. Ladies and gentlemen, that's all sand. All of it is sand in the box. It's sand to distract you from the red bike that the defendant is riding in on when she fired those shots into the home, killing Shamir Poole, who's not here today to be able to tell her side of the story. We'll never know why, as you heard Dee Dee tell you and Miss Jordan tell you, that as Shamir looked out the window, she went, oh, shh. We'll never know what the end of that sentence was, and we'll never know why she was saying it, because the defendant's bullet killed her. Ladies and gentlemen, don't pay attention to the sand or you will miss the bike. Ignore the sand. Don't be like the Border Patrol agent who saw the sand, looked through the sand every single day, only to learn that he's let a year go by of new red bikes coming in, that he couldn't stop because he was so distracted by the sand in the box. What you should pay attention to. Lamar's testimony. We talked a lot about Lamar's testimony, ladies and gentlemen. He got a call from Shamir to go see what was going on at her house. He got there and saw Nene and Michael were arguing. He walked Nene down the sidewalk. Shamir, Dee Dee, and Keisha Jordan arrived. They were moving Nene's things to the curb. The defendant arrived. Her and Dee Dee argued. Dee Dee told you they argued. Nene told you they argued. Lamar told you they argued. They argued, but it was verbal. Dee Dee went inside. Nene didn't went inside. The door closed. Lamar said he doesn't know who closed the door. The defendant said she didn't know who closed the door, but it closed. Lamar was outside of that door. So was the defendant. And what Lamar told you next, ladies and gentlemen, is that the defendant started shooting. He said it when I put him up there the first time. He said it when he came back, and he said it when the defense attorney came back and asked him some more. He maintained the same story. He's told you the same thing over and over again, that the defendant shot into that home and he ran to try and get the gun out of her hand. Not far, he showed us, it wasn't a far distance. Ladies and gentlemen, you heard from Keisha Jordan, Shamir's mom. She told you that around 7 a.m. she went to work at Kroger. She told you that about 2 hours later, she got a call that she needed to get over to Shamir's house where Michael and Nene were staying, because there was an argument going on between Michael and Nene. She told you that Shamir was ready for everybody to go. She wanted Michael gone, Nene gone, everybody gone. She says about 20 minutes later, she got there. She arrived at 440 Thomasville Boulevard, apartment 149. And then, ladies and gentlemen, what she told you next was that when she got there, she went into the home. Things were still going on. They were still trying to get Nene's things out of the home. They were putting her stuff outside, but she couldn't recall at that point the time and how close in time things to happen, because she said it all now just seems like it all happened so quick. What she does tell you, ladies and gentlemen, is that while she was in that house, while her children were in that house, she heard shots. And then she saw her daughter's lifeless body on the ground. Ladies and gentlemen, you also heard from Demetria. She told you Shamir got a call to come see what was going on at 440 Thomasville Boulevard. She told Shamir they shouldn't go. Remember, Dee Dee told us that she had just had surgery. She didn't really feel up to it. She didn't think they needed to go anyway. They were about to move and get their own place together. She did not think they needed to go. But Shamir insisted on it. She wanted to go and make sure things were okay. And as Ms. Jordan has already told you, as Nene told you, as Michael told you, Shamir was ready for Nene and Michael to move out of her home. That was her home. That's all she had for her and her children. That's what Dee Dee told you. Shamir said she would just take an Uber. Dee Dee, you don't want to take me? I'll take an Uber. So Dee Dee decided she would go with her sister. They got there, and then he was down the street talking to Lamar. They were down there. Shamir and Dee Dee and Miss Jordan go into the home. They start to get the things out, and the defendant arrives. When the defendant arrives, Dee Dee tells you, the defendant told you, they had an argument. They argued about the defendant feeling like her daughter was being improperly evicted. Dee Dee said, this is my sister's home, and she went on back in the house. She tried to walk away from the altercation. She goes inside, she closes the door. She tells you she's the one that closed the door. Shamir looked out the window and began to say, oh, shh. And before she could finish, shots were fired. Dee Dee saw Shamir hit the ground, realizing she had been shot in the head. One single gunshot to the head. Ladies and gentlemen, Dee Dee told you that she went down to aid her sister. And after she went down to aid her sister, she still hears gunshots and she reaches over and she starts to fire shots. She showed you what the gun looked like. You saw the photos of it. She doesn't deny that. But she says that happened after her sister had already been shot in the head. Ladies and gentlemen, then you also heard from Nene, the defendant's daughter. When she woke up, her and Michael argued about her transportation to work. Neighbors came over to intervene. The arguing continued. She tells you that Michael called his family. Lamar and Nene walked down the sidewalk because Lamar was one of the neighbors that came over. He came to intervene. Shamir called him. He went to try and stop things from escalating. And that's what he did. He walked Nene out. They walked down the sidewalk. She walks down the sidewalk with Lamar and uses his phone to call the defendant. Ladies and gentlemen, the defendant told you, and Nene even said, that Lamar and Michael took her out of the home. But she walked down the sidewalk with Lamar. She used his phone. She didn't seem to have any fear of him. They went calmly and talked. In fact, she waited with him until her mom got there. He went back with her to try and help her. He waved down the defendant. The defendant told you he waved her down. Lamar told you he waved the defendant down, and the defendant told you herself that he waved her down. He was just trying to help, just trying to de-escalate the situation. He saw that Nene was being put out, and he was just trying to help and make sure she got back to her mom. Michael's family arrived, and the defendant arrived. That's what Nene told you. Nene says she went back into the house to get her ID. Lamar told you Nene went back into the house to get her ID. She said she was trying to get out. Ladies and gentlemen, she also told you she was sitting on the edge of the couch. That doesn't sound like someone that was afraid, that couldn't get out. She said she was sitting on the edge of the couch. Her mom told you she was sitting on the edge of the couch. As she opens the door, she hears the gunshots. She sees her mom and Lamar's husband. Ladies and gentlemen, you also heard from Michael. Michael and Trinikia give a very similar account of things that happened. They were there from the start to the end. The argument started that morning. Michael woke up. Him and Nene argued about her transportation to work. The neighbors come over to intervene. The arguing continued. Michael called his family and Nene called her mom. Lamar and Nene walked down the sidewalk. Again, Nene walked down the sidewalk with Lamar. Lamar was clearly calm. He just walked down there with her. He was talking to her, let her use his phone, waited with her for her mom to come. He wasn't aggressive towards Nene, but the defendant would have you believe that he was aggressive towards her for no reason, just to take her phone. To take her gun is what she would have you believe. Michael's family arrived, the defendant arrived. Nene and Dee Dee argued. Everyone's told you Nene and Dee Dee had an argument. Dee Dee went into the house. Michael saw Lamar and the defendant tussling over the defendant's gun. Shamir was standing by the window. He heard shots. He saw his sister Shamir had been shot in the head at this jump. She was shot in the head, laying on the ground. Dr. Karen Sullivan testified. She was the expert. She was here for a limited purpose, ladies and gentlemen, just to tell you what her autopsy report revealed. Shamir was shot one time in the head. Shamir died from a gunshot wound to the head. The manner of death was a homicide. Shamir Poole, she's not here to speak for herself. Shamir was a mother. She was a daughter. She was a sister, a niece, a cousin, a friend. She was well loved in the neighborhood. In fact, at the time of this incident, she was at her sister's home trying to care for her after she had had surgery. Ladies and gentlemen, Shamir deserves to be here today, but she's not, because the defendant, instead of just getting her child, getting her grandchild, and leaving, she instead decided to fire shots into a home that led to the death of Shamir Poole. It was unnecessary. Nene wasn't afraid. Nene only acknowledges that she ran after she heard shots. Yeah, she told you she was trying to get out the home, but she also told you, ladies and gentlemen, that she walked calmly down the sidewalk with Lamar. She also told you that she was sitting on the edge of the couch. Nene wasn't afraid of anything going on there until her mother let off 3 shots into a home where people were standing. And then her mother left her and her grandchild. Nene was left to run off into the woods. The baby, both of them left the baby. Ladies and gentlemen, I ask that you follow the law. Put your personal feelings aside and hold the defendant accountable for her actions. She intentionally shot into the window of the home of Shamir, where Michael, Keisha, Demetria, and Shamir were located. Shamir was shot in the head, and now Shamir is gone. We don't tolerate this behavior in our society. And for that reason, ladies and gentlemen, I ask that when you all go into that jury room and begin your deliberations, that you find the defendant guilty of all counts of this indictment. 2 counts of felony murder, 4 counts of aggravated assault, 1 count of criminal damage to property in the 1st degree, and 1 count of possession of a firearm during the commission of the felony. Because, ladies and gentlemen, Shamir Poole deserves to be here today, but the defendant's actions didn't allow it to. Thank you.
All right, members of the jury, we've now reached the point of the trial where it's my duty to charge you on the law that applies to this case. That charge, essentially where I read the law to you, is a process that takes about 15 to 20 minutes. So first I'll ask if anyone wants to take a break before I do that. Seeing none, we'll forge ahead, and I'll note you will receive a copy of these charges during your deliberations. You are now considering the case of the state of Georgia versus Andrea Nicole Rivers. The grand jury has indicted the defendant with the offenses of felony murder, 2 counts, aggravated assault, 4 counts, criminal damage to property, and possession of a firearm during the commission of a felony. You will be provided a copy of the indictment during your deliberations. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in her favor. This presumption remains with the defendant until it's overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I give you in the charge to the facts as you find them to be. Your oath requires that you decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard, or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion is not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances, by direct evidence, from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion, or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but must also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. The jury must determine the credibility of the witnesses. In deciding this, you must consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The credibility of a witness may be attacked by disproving the facts to which the witness testified. In determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to challenge the credibility or believability of any such witness. This would include evidence of bias toward a party, such as specific instances of conduct of the witness in question that may relate to the witness's bias toward a party. In determining the credibility of any witness whose credibility has been challenged, as I've described above, and any testimony by him or her in court, you may consider, where applicable, evidence offered to support the credibility or believability of any such witness. This would include lack of bias towards a party or truthful conduct, specific instances of conduct of the witness that may relate to the witness's lack of bias toward a party. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony or statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify, and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. Evidence of prior difficulties, or lack thereof, between the defendant and a witness has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the witness, the reasonableness of any alleged fears by the defendant, and the reasonableness of any alleged fears by the defendant. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. You've heard evidence of the character of the defendant, and the character of the defendant for a particular trait, more specifically her handling of a firearm, in an effort to show that the defendant likely acted in keeping with such character or trait at pertinent times, or with reference to issues in this case. This evidence has been offered in the form of the opinion of the defendant. You should consider any such evidence along with all the other evidence in deciding whether or not you have a reasonable doubt about the guilt of the defendant. The defendant is charged with a crime against the laws of the state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances, or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of the words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that 1, the acts of a person of sound mind and discretion are the products of that person's will, and 2, a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. A jury is not authorized to find a person who is merely present at the scene of the commission of the crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault with a deadly weapon and criminal damage to property in the first degree are felonies, which I'll define for you shortly. You may find the defendant guilty of felony murder if you believe that she caused the death of another person by committing the felony of aggravated assault with a deadly weapon or criminal damage to property in the first degree, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when death actually occurred. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. For possession of a firearm during the commission of a felony, the state must prove that the defendant, 1, had a firearm, 2, on her person, and 3, while committing a felony, which is a crime against or involving another person. Felony murder, aggravated assault with a deadly weapon, and criminal damage to property in the first degree are felonies. The term firearm includes any handgun, rifle. The term firearm includes any handgun. A person commits the offense of criminal damage to property in the first degree when she knowingly and without authority interferes with any property in a manner so as to endanger human life. The defendant has raised a defense that even if she committed the act described in the indictment, there are circumstances that justify it. Once this defense is raised, the state must disprove it beyond a reasonable doubt. Sometimes a defendant's threat or use of force is legally justified, and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when, 1, she reasonably believes that such use of force is necessary, 2, to prevent death or serious bodily injury to herself, a third person, or the commission of a forcible felony, which means a felony that involves the use of force or violence against another. Aggravated assault is a felony. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. A defendant is not justified in using or in threatening or using force if she provokes the threat or use of force against herself, intending to use that threat or force as an excuse to harm the other person, or is attempting to commit and fleeing after committing a felony, or is the initial aggressor, unless she withdraws from the encounter and clearly communicates to the other person her intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. For the defendant's threat or use of force to be justified, 1, the defendant must believe that her threat or use of force is necessary. 2, that belief must be reasonable. That is, a reasonable person would also believe that the threat or use of force is necessary. And 3, the defendant's reasonable belief must be what prompts her to threaten or use force. A person who is not the aggressor is not required to retreat before being justified in using force she reasonably believes to be necessary. The law provides that criminal actions shall be tried and indicted in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, that the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue may be proved by direct or circumstantial evidence or both. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, did on or about August 24th, 2021, commit one or more of the offenses as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of an offense, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. As it relates to the form of your verdict, you will be provided with a verdict form that has been prepared by the court and the parties, which will list each count and have a blank for you to initial and sign for the form of your verdict as to each count, and which on the next page would be a signature for the foreperson of the jury. By no ruling or comment that the court has made during the progress of the trial, has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict, based upon your opinion of the evidence, according to the laws given you in this charge. You're not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should only do so after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you're convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all, and it must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. All right. Any objection to the charge thus far from the state? Mr. Strozier? All right, members of the jury, you may now retire to the jury room, with the exception of juror 34, if you could stay with us. But remember, for those that are retiring to the jury room, please do not begin your deliberations until you receive the indictment and the exhibits. We're going to be getting those back to you. That's going to take a few minutes, but we'll have to those to you shortly, and then you can begin your deliberations at that point. A note on how that'll work going forward, we're here at your pleasure. So as I mentioned before, and how we have been conducting it is we'll usually break at 5 if you're still deliberating at that point. But if you give us an indication that you'd like to stay a little longer than 5, maybe because you're close to a decision, you can let us know. Otherwise, the plan right now will be that once we get to about 5 o'clock, we'd break for the day, come back tomorrow to resume deliberations at 9 o'clock. All right, thank you. All right, juror 34, as you might have gathered, we do try to pick a few alternates, and you were our last alternate. And so what that means at this point is only 12 jurors can make this decision, but there's still the possibility that we may need you if things come up during deliberations. So what I would ask is, because we're closer to the end of the day, if we need you again, we would bring you back tomorrow. So at this point, I would say that you can feel free to go home. And then we're going to give you a call once we know, one, if the case has been resolved and you're excused from your service, or 2, hey, come on back down, we need you. And we should have that call for you, I'd imagine, giving you some kind of update by tomorrow at the latest. And then in the meantime, while you're gone, the obligations of your jury service will still stay in effect, meaning please don't do any research at all about the case and don't discuss the case with anyone at all. Any questions for me before you leave today? All right. Well, if we don't have a chance to talk again, thank you so much for your time and your service in this case. All right. All right, counsel, on the charge of the jury, I did make one kind of on the fly alteration that was on page 6, where it was defining the term firearm for possession of a firearm during the commission of a felony. The pattern charge says the term firearm includes any handgun, rifle, or shotgun. But from my reading of the indictment, since it only references a handgun, I just excluded rifle or shotgun. And so, my thought is we've got Court's Exhibit 4, which was going to go out to them as instructions. I could just strike through that language, and then we go from there. Any thoughts?
No objection.
All right, then I'll strike through that language on Court's Exhibit 4. We'll have a verdict form to include with that, as well as a copy of the indictment. And if we could have council confer, or at least, I don't know if you're ready to announce which exhibits you think go back and which ones don't.
Just D1 from us.
All right. We've got that photograph, which is D1 on the state side. Maybe we'll do it this way, Ms. Willingham. Are there any exhibits you feel you have to hold back because of the continuing witness rule? So like the recordings, for example, the 911 calls.
I mean, they don't go back because they can't play them.
Yeah.
But yeah, but other than that, no.
All right. So you'd hold back the discs.
Yeah.
Okay. And that was just 2 through 4. But otherwise, everything else, the photos, the CAD reports, the autopsy report, you think that all goes back?
Yes, Judge.
All right. Any objections to that, Mr. Strozier? Okay, then I think we're agreed on what's going back to him. If y'all could take a look at that before it does. And I think by the time it gets back there, we'll note deliberations starting at about 3 o'clock. And if you could just stay, I think we've got your phone numbers. We'll give you a shout if we get a note or question from the jury in the interim. If there's nothing further, we'll be off the record. All right, Ms. Smith, still alive. Can I get Court's Exhibit 4 if you still have it? Did I not mark 4?
No,
Well, shoot.
I mean, the updating one.
Yeah. Okay. Okay, that's fine. You're right on it. 3 was the first draft, right?
Yeah.
Okay. So here's 4, and I'm going to strike through on page 6. All right. We could use this verdict form if you want. And you've got the indictment too, I think, on top there. Say what? Is Mr. Sterling around?
No,
Put it down. Oh, we might still be having a hearing on it. Yeah. Hey, I think we might still need Coleman. Might still need Coleman. Okay, and then we can give Russell and Sterling a call and come on back. Let's see what we can do. We might just do that on here. Okay, exhibits and everything are going back. There they go. For what?
Judge, we're off the record, aren't we?
We are, sir.
I want to thank you for giving my client a fair trial, sir.
Well, I appreciate that, and I'm glad we were able to get through it, and I thought it was well tried by everyone. So it's not over yet, though. Let's see what where we go from here.
My client feels like she got a fair trial.
Well, I'm glad to hear that as well.
Well, everybody likes to complain and just, and bitch and whine about some things that the judge does, and almost nobody ever tells the judge Tyson did a good job.
Well, thank you. We'll leave a comment box at the front for you next time, maybe, and we can do a little comment card.
You know what I mean?
I know, and I appreciate the gesture.
Judges are often criticized and very seldom complimented.
Well, thank you, Mr. Strozier. We'll be in recess till we get some word. They have the exhibits, so they should be getting to go.
I think we're gonna have a verdict today.
Well, no.
Let them know.
Baby. You leave?
I'm going to the restroom.
I won't see.
Some spare coffee. So. What, hey? The lady that said that she's on bond? Oh, I didn't know that. Hello? Hello? Hey. How you doing? Hey, can you, of course, that you, what's the last name of the person you brought back? Hey, how the guy that you took down, what's his last name? What they call him? They saying that they said he need to come back, bro. Oh, okay, okay. All right. I thought it's a. Still got a court to go? No, they got people back there. But that's when you stay off. I mean, like, shit, we just deliver, I can't leave anyway. I'm just gonna be mad, man. Yeah, shit, with my leg, so I'm be here with you. I don't think they're gonna come back and they just merge up. Hell, how about they ever? I'm surprised. I ain't get to hear how it was. Be surprised. They gonna make them show them, tell them what they had upstairs. When they come to murder you up the check before we tell them they came to screen these. No disrespect to the families, but we got a court to run. We can't just let you act outraged. And walk them out. Come on. Time they come with. Oh, well, get up. Time the first one. Get up. That's how I do it. That's how I do it. I know this your court. Yeah, oh yeah. But that's just how I do it. When the judge already told them they can't restrain, first time they make any kind of, come on. Like, yeah. Shit, I gotta keep it.
You just be back on she's free. I guess he was getting ready to put her in custody. He's like, she got her bonds? I'm like, yeah.
Oh, yeah.
Look like he was getting ready to put her in custody.
Take it to the bag.
Yeah.
Take it to the bag.
So how is the door like this on the other side? And they kind of connect like a little walkway?
Real thing around. Not yet. I'm gonna let it be.
It's trying to be here in about 15 minutes. 15 minutes? Yeah. Then I go forward with the motion of discipline. What they gonna do? You're gonna ask for emotional harm. I thought you were gonna say.
You should tell them to turn to about 15 minutes.
Okay. This,
I appreciate it.
yeah.
When it hit Smothers back, let him know. Smother.
You gonna what? Smothers. Oh.
Deputy Smothers.
Oh.
Let me smooth.
What's that friend's name again? Michael T. Sterling. Sterling, like the silver? Yes. Um,